To order, and the clerk will please call the roll.
Chair Smithy,
Here.
Vice Chair Wu, Representative Bowers.
Here.
Representative Cook, Representative Jones.
Here.
Representative Little,
Here.
Representative Louderback,
Here.
Representative Money, Representative Moody, Representative Rodriguez Ramos, Representative Verdell.
Okay, we have a quorum present, so we'll go ahead and begin now. And the record will show that Ms. Rodriguez Ramos is present. Thank you for being here. I know we've got several members that have other committees going on or bills to lay out. It doesn't indicate a lack of interest that they're not here. They'll be joining us as they can. We're also glad to have Ms. Rodriguez Ramos and Mr. Little, who were prevented last week from being here because of the weather, the inclement weather last week. So we appreciate them being here as well, and appreciate all of you being here to testify on these important bills this morning. Now, if you have, we welcome everyone who's here to testify. If you wish to testify, if you don't want or need to testify, you can fill out an affirmation without testimony. But we would ask that if you do testify, that you fill out the electronic affirmation. That's essential to doing that. And if you haven't done that already, if you would do that. One of the problems in these committee hearings for the chair is the order of bills, because the members that are advocating these bills have other business to attend to. We never know when they're going to come in, and so we don't have a definite order or agenda. So we'll just do the best we can to try to get these bills heard as quickly as possible. We'll try to give you as much heads up as possible too. The record will show that Chair Cook is present. So so we'll go ahead and begin hearing the bills that we have. We have Mr. Cortez is present. Do you want to lay out your bill, Mr. Cortez?
Yes, sir.
Okay. And so the chair lays out House Bill 727 and recognizes Representative Cortez.
Thank you, Chairman.
And let me, before you start, let the record reflect that Vice Chair Wu is present as well. Members, let me remind you, if you're when you speak, your green button needs to be on, and you need to speak directly into the microphone so that it can pick you up. And Mr. Verdell, did we catch you on the initial roll call? Okay, we did. Okay. Go ahead, Mr. Cortez. Thank you.
Good, Chairman? Okay. Good morning, Chairman Smithy, Vice Chair Wu, members of this committee. I may say, Chairman, this is a very attractive committee. Amazing, amazing. A little intimidated here, sir.
Well, flattery will get you everywhere, I think.
Thank you for the opportunity, Chairman, to lay out House Bill 727 before the committee. As crime rates rise in Texas, it is imperative that the public be protected from dangerous situations, particularly involving vehicle burglaries. The danger associated with vehicle burglaries is accelerated when firearms become involved. In fact, the Bexar County Sheriff's Department observed that firearms stolen from vehicles were used several times against law enforcement officers and innocent victims. House Bill 727 will classify a vehicle burglary as a state felony rather than a misdemeanor if it is carried out in conjunction with one of the following factors: possession of a firearm, theft of a firearm, using a stolen vehicle, or burglarizing multiple vehicles during the same crime. I want to thank our Bexar County Sheriff, Javier Salazar, and you'll be hearing from him shortly, Chairman. I appreciate him bringing me this bill. He's here to provide some testimony on the importance of this bill, and I look forward to working with each of the committee members here to see this legislation through. Thank you, Mr. Chairman. Members, I reserve the right to close.
Okay. Any questions for Mr. Cortez? We appreciate it. I'll go ahead and call the witnesses.
Yes, sir.
We'll go ahead and call first Sheriff Salazar. We appreciate you being with us this morning, and you're now let me tell you and all the other witnesses, when you get up to testify, if you would, state your name, and if you're representing someone, who you're representing, and tell us right off at the front whether you're for or against the bill.
Yes, sir.
Thank you very much.
Thank you, Mr. Chair, members of the committee. Thank you all so much for having me. And I'm Sheriff Javier Salazar from the Bexar County Sheriff's Office. And I certainly come here with all respect, representing the 2 million Bexar County residents that I'm sworn to protect. I am in favor of this bill. As the representative mentioned, we brought it forward to him to address a real problem that we're seeing in our community. It is something that I mentioned last legislative cycle, came in and did similar testimony. And during that testimony some time ago, I kind of foreshadowed a scenario that we're seeing play out now right in front of us on a nightly basis, just about. With regard to vehicles of burglaries, we're seeking to increase the penalties for certain vehicles of burglaries. I'm in my 32nd year in law enforcement. 24 years, I was blessed to work with the San Antonio Police Department, and then in 2016 I became the Bexar County Sheriff. So the past 8 years I've been sheriff of the county, and I've seen obviously crime ebb and flow. Very early in my career, burglary vehicle was reclassified as a misdemeanor, which may have suited its purpose over the years. However, we're seeing this increasingly become not just a property crime, it's increasingly becoming a violent crime because of the presence, the introduction of weapons that unfortunately are being left in so many vehicles on a nightly basis. Now, we do, as with any other crime, we don't just want to take an enforcement approach to it. I think that's a one-dimensional approach. So there is a public education aspect to this that we are pressing forward on, and we have been for the past several years, just educating people on the need to not leave your weapons in cars, because a legal weapon becomes an illegal weapon just like that once it falls into the wrong hands of a car burglar, whose sole purpose in many of these cases is that firearm. They're not breaking in for spare change. They're not breaking in for the gym bag or the laptop bag in the back seat. They are strictly looking for guns. And unfortunately, with increasing frequency, they're finding guns. Many times they go right under the seat, into the glove box, and into the center console, and they're gone within minutes. But one of the scenarios that again, as I foreshadowed several years ago, and is now coming to fruition, it is now pretty commonplace that these burglars, and we've got videos to prove it up, will then steal a gun and then continue to carry that gun throughout the commissions of the burglaries in the neighborhood. Many times they're holding a gun in their hand, and in some instances even pointing, as they're burglarizing, rifling through the car, they're pointing that firearm at the front door of the residence, waiting for somebody to come out and confront them. We've seen instances where gunplay has occurred. Homeowners have been shot as they come out to investigate a bump in the night. And in some instances, suspects have been shot by homeowners. And so we're hoping to just bring an end to it all by addressing this. And we're hoping to be able to count on your support to help us out with strengthening this offense.
Okay. Thank you, Sheriff. One of the most important things, most difficult and important things this committee has to do is to, assign a value of punishment to a crime, and to try to make sure that the system is as equitable as possible. So it's a very, very interesting situation when we talk about how much punishment or potential punishment to assess to an offense. And so I hope you understand it's a very it's very difficult to make sure that we have an equitable system in place. Let's see, are there any questions for the Sheriff? Mr. Verdell?
Thanks for coming, Sheriff. One quick question, which I'm not sure, that's why I'm asking you, is it a felony already to steal a firearm?
It is a felony to steal a firearm already, but we're also looking to add that wording to this to bring it all in under one offense.
Okay, roger that. Appreciate it. Thank you.
Yes, sir.
Okay.
Mr. Chair,
Yes, Mr. Little.
Mr. Salazar, I'm sorry, Sheriff Salazar. The purpose of this is to enhance penalties dealing with burglaries of vehicles, is that right?
Certain burglaries of vehicles, yes, sir.
What vehicles?
So anytime it involves a firearm, the carrying of a firearm, or the stealing of a firearm during the course, or many times what we'll see is they won't just burglarize one vehicle. They'll go in and hit a whole neighborhood. And so we're looking to make it any time that you're hitting more than one vehicle or more than two vehicles in the same course of criminal conduct, that also be considered for a felony charge.
Okay, You have to excuse me because I'm genuinely confused. I understood Representative Guerra's testimony to be dealing with any type of vehicle in a neighborhood and yours as well. As I'm reading House Bill 727, it makes a change to 3004 of the Penal Code. It's subsection D 2B, capital B. It says the actor broke into or entered a vehicle or part of a vehicle that is a rail car. This is a rail car section of the Penal Code, and I'm confused as to why this has been inserted here. And if I'm misunderstanding it, or if other members of the committee have the ability to correct me, please do. But the way that I read this statute is this capital B subsection of 3004 deals with breaking and entering a rail car, not any other type of vehicle. Am I wrong about that?
So, I'm happy to weigh in.
Oh, yes, Mr. Moody.
So you've got in 3004, as it stands now, certain situations that bump it up to a state jail. So multiple convictions, it creates a state jail, and then if that vehicle is a rail car, it's a state jail. So the way that I read 727 is it's creating other fact scenarios to raise it up to a state jail felony alongside the rail car. It also tweaks the rail car language, and I don't know if that's a cleanup, broke into or entered. The way they've changed the rail car part, I think, is mainly cleaning up the prior language in 3004, and then it adds to other things. That's my understanding of it.
Yep.
And, Mr. Chair, if I might-
Mr. Little.
the part I'm confused with is why this modification or step up in the penalty offense was included under this larger section B that deals with entry into a rail car. I'm confused about how it relates to that. So if you look in 3004 and it's D
It's just an enhancement.
2B says the vehicle or part of the vehicle broken into or entered is a rail car, and then it begins but we've added these Romanet subsections underneath that are a little bit confusing to me. Do you understand the application of the modifications to this provision?
So, no, sir, I didn't add anything with regard to rail car, but as I read it, it's entered a rail car or possessed a firearm or the other scenarios that I described. I don't see it as a rail car and multiples.
Mr. Chair Wu.
It's what Representative Moody, this bill does two separate things. And I think the problem is that the BA doesn't talk about it.
I concur.
Yeah.
I'm
So,
struggling.
This will be a nice fat point of order right there. So, no, I think you caught the exactly right thing. It's like the beginning section, these are all modifications, these are all different kinds of enhancements. I think the enhancement that the sheriff is really going for is F. It's on page 2. And the D2B language is a penalty enhancement for all kinds of thefts if the theft involved the actor enter into a vehicle or part of a vehicle that is a rail car. Stolen.
It just got wedged into an interesting place, Sheriff, and I'm trying to understand why it got.
It was
placed there.
I think I mean, based on this, it was originally already in the code like that.
The rail
Yes.
car part.
Yeah.
Yes.
I think, or do you mind if I speak for a minute? I think if you just added a C section, that would fix it instead of the B section.
Mr. Chairman. Mr. Louderback.
Sheriff, would you please work with the bill offer to get some of those changes made? It sure clarify things, make it a lot bit easier to read, and it certainly reads that way. And I have a question, what are your numbers in Bexar County as far as your burglaries?
Well, we'd have to pull numbers. Right now, thankfully, our numbers are trending downward for the moment. But as you know, being a former sheriff yourself, that could change at any given time. Certainly when you're talking about things like, especially in Bexar County, hosting things like the NCAA Final Four, hosting things like the college bowl games, all it takes is one or two events like that, or the big concerts that we host, to see a crime like this skyrocket. Especially in light of the fact that we have had instances where criminals or groups of criminals are traveling from other parts of the state to commit burglaries in San Antonio when one of these events happens.
Mr. Little?
So Sheriff, just a continuation of that, do you have any numbers at all? Can you give us a number?
Yes, sir.
I want to know if it's gonna affect our state correctional resources.
Yes, sir. We can certainly get you those numbers before we leave today. We'll make sure that we leave
I
those
think it'd
numbers
be
behind.
helpful for the committee to know.
Yes, sir, Mr. Redd.
Mr. Little, did you have something?
Just a question, Sheriff Salazar, what do you think the deterrent effect is of this meaningfully in Bexar County if it moves from a misdemeanor to a state jail felony? Do perpetrators base their decisions on one or the other, or what do you think the effect of this is going to be?
Well, right now my jail is at capacity, and I'm certainly not relishing the idea of adding to that jail population that we have. What I do believe that this does is put some real teeth behind a law that I think, unfortunately, because it's quote unquote just a misdemeanor, they may be more tempted to do so. But if we can catch these folks and put them through the system now with a felony offense, it wouldn't be such a revolving door, which is unfortunately what we tend to see sometimes in our criminal justice system.
Understood.
Okay. Any other questions? Mr. Burdell?
Hey, Sheriff, I just wanted to point out my parents and my brother, who's a cop, have both had their cars broken into in Bexar County.
Yes, sir.
Yeah, over by the Bass Pro Shop area.
Yes,
So,
sir. That's a big area for us.
Ms. Jones?
So I just want to be clear on a couple of things. So the first thing is that you're trying to add a state jail enhancement for if when you break in and there's a gun. I guess my problem as a 30-year criminal defense lawyer is I think I would have a bunch of fun when I break into a car, I don't know if there's a gun in there.
It's when
So-
you steal
so-
the gun.
Or when you have one.
So, well, I mean, if you have one, I mean, there's something for that already, right? I'm just trying to figure out what this cleans up. But I break into a car, maybe I break into the car because I'm an addict, and I just want to see what I can sell, like anything. Maybe there's money in there. And you're telling me that once I break into the car, for whatever reason, if there's a gun in there and I decide to take that now enhances it to a state jail felony.
The possession of, the possession of that gun would enhance it to a state jail felony. Yes, ma'am. But the mere breaking into a car that happens to contain a firearm, I don't believe that would trigger this. I would be stealing that gun and then possessing it further would trigger it.
Yeah, but that's already a crime. So I'm looking at, and I always look at this with law enforcement. If you have an ambiguous law, a good criminal defense lawyer is gonna end up creating reasonable doubt.
Well-
And so I'm just trying to figure out, once I break into the car and I realize there's a gun there, you're saying it bumps it up to a state jail felony if I take the gun and I keep the gun.
If you take it and possess it, and then it makes the next vehicle you break into a felony as well, because now you're possessing that gun from the earlier one. It doesn't allow you to steal that gun and then go commit a string of misdemeanors along the way. Now every one that you commit while possessing that gun that you stole from the previous car or 2 cars ago now becomes a felony instead of a misdemeanor.
Mr. Chair,
Mr. Little?
just a couple more questions, Mr. Salazar, or Sheriff Salazar.
Yes.
So, as I understand it, it would be a strict liability offense. If I break into a car and I grab a bag and the bag has a firearm in it, I'm now in possession of it, having stolen it, and it is a state jail felony, whether I know there's a gun in the bag or not, because I intended to steal the bag. Would you agree?
Well, certainly that could be argued.
Well, That's what we're doing right now. I'm trying
Yes,
to
sir.
figure out whether it is a strict liability offense or whether I have to knowingly steal a firearm as opposed to stealing a bag out of a vehicle that may have a firearm in it.
Well, and the way it is written now, and the way I would see it, that yes, you would be now guilty of that felony, or you'd be committing that felony. I mean, certainly open to if that were to come to a discussion and we make that distinction, I'd certainly welcome the opportunity to be part of that conversation.
Thank you, Sheriff.
Mr. Louderback, I'm sorry.
Sheriff, the rail car issue, like in Harris County, let's just take it as an example. There's a lot of new vehicles on rail cars and there's used vehicles on rail cars. This might be an area that we're talking about being burglary of motor vehicle happening. Would that be right?
I'm sorry, Mr. Rip, I didn't follow that.
On rail cars transport new vehicles which are burglarized and used vehicles which are burglarized. Could this be a part of a rail car? Because crimes occur on rail cars with cars.
Well, I
vehicles.
couldn't speak to the rail car aspect of this, sir. What I'm seeking to curtail is just strictly a car parked in a parking lot or out in the street in front of a residence, and that car being broken into and having a gun stolen. I couldn't really speak to the rail car aspect
But
of
this
it.
bill may be addressing that, maybe addressing more than just that.
It certainly could.
Yeah, thank you.
Let's see, Mr. Wood.
We're not attacking you, I promise. We're just trying to get through,
Yes, sir.
the logic of this. So I'm actually, I was having the same thought as thinking about this legislation the same way Rep. Jones was thinking about it. So we're talking about two separate things. A BMV does not require that someone takes something. It has to be it's a burglary, it's the breaking with the intent, right? So you break into someone's car, you look inside, it's all crap, and you walk away. The BMV still happened, even though you stole nothing, right? So the actual breaking, the act of the breaking, of crossing the plane in that action is the full crime. Does that make sense? So if you're taking something that happens after the initial crime has already occurred, and that second point, right, it does not become your thing, become this applicable to this part of law until the weapon is taken, correct?
Well, but unless you brought a weapon with you to commit that burglary of motor vehicle. So you're not just committing a misdemeanor burglary of motor vehicle, you brought a gun
Okay,
with you.
that's a separate thing. Let's
Sure.
So, but I think the issue, what I think Rep. Jones is saying is that, okay, a regular BMV, the criminal activity occurs the moment the breaking occurs, right? The moment you cross the plane, you have broken the law. But if you're saying that there is the offense changes when at this point you take something else, you're changing the elements of a BMV. That's number one. Number two, I think to Rep. Jones' point is, well, once you have taken possession of the gun, it is in your possession, whether for 5 seconds or 5 years, you have committed a separate theft. That's a theft of a firearm. It's a higher level of crime, and it's already a felony penalty. And it would be easier to prove the theft of the firearm than to prove up the enhanced backdoor way of going to the BMV. I'm just trying to think about this. If I was having to prosecute this, when I was a baby prosecutor, I would much rather prosecute the possession of a stolen firearm than I have to go backwards and prove the breaking and prove that it came from this vehicle. It has to prove that it came from this particular BMV to enhance it. Right? Just trying to think through it logically.
Answer.
Yes, please.
Okay, well, and that's fine, Mr. Representative, for that vehicle, but I'm talking about the one where he keeps the gun now, goes to and commits subsequent burglaries of motor vehicles. Those second, third, fourth, fifth, 10th cars are no longer misdemeanors. Those are now felonies. Because of the continued carrying of the weapon, but also because they're hitting more than one vehicle in the same course of criminal conduct.
I mean, I think that's not terrible, but you would have to, if I was a prosecutor, I would be required as an element to prove that that weapon was in his possession or in use during each one of those separate break-ins that could have happened hours apart.
But again, in the scenarios that we're talking about that are playing out in our county, and again,
Right.
I'll be happy to share the pictures and videos with you all of them committing burglaries of vehicles while a lookout is in the driveway in the driveway with a handgun, or the burglar himself or herself has a handgun in their hand while they're rifling through the car with their.
I mean, I think what would probably better solution is just tell people that they can't leave unlocked firearms in their unlocked or their vehicles out in public.
And we are doing that. Trust that was earlier when I said I don't want to take a one-dimensional approach and only rely upon enforcement. There's a public education aspect. We spend quite a bit of time educating the community on the importance of not leaving your guns unattended in cars. The thing that I'm constantly reminding folks of is that, look, responsible gun ownership is a 24-hour endeavor. It does you no good whatsoever for your home defense or for your liability with regard to your gun if you're asleep in bed at night and that gun is out underneath the front seat of your car for 8 hours. You've got to have that gun with you for it to do you any good, but also to limit the opportunity for burglars to come out and steal it from your car and use it in further offenses.
No, I totally understand. I think that secondary aspect, I mean, we can totally work on
Sure.
this.
Ms. Jones? Yeah.
I think this bill, I'm sorry, I think this bill is making it harder for prosecutors to prosecute and making it easier for defense lawyers to find reasonable doubt. I understand the problem that you're trying to fix. And I say this because I've been a 30-year criminal defense lawyer. And boy, do I love reasonable doubt. And when you go to prove a case, you've got to prove every element of the offense beyond a reasonable doubt. That it happened in Bexar County, that, all these different elements. You literally, at least with this bill, have created a scenario to Vice Chair Wu's point. A BMV is a BMV. You don't have to take nothing, right? And I'm using ebonics for emphasis, by the way. But now you've got to prove, and I also think there's a problem with intent, right? Since the focus is on the gun, there's got to be an intent. The Constitution requires it to take a gun. You may not know there's a gun, which again causes problems, which I think goes to Rep. Little's question about strict liability. Because if you're making it strict liability, then the intent to take the gun really doesn't matter. I mean, right, you take something that's got a gun in it and it's strict. But now when you talk about proving that they took the gun and then they broke into this, now the prosecution has got to prove like the chronology of it. How do you, that's hard. Like when did a fingerprint get to a place? Was it at the time of the crime or was it there because you were my friend and I was in it? So you're making it more difficult. And then you brought up a scenario where you go to the car with a gun and then you get to the car and then you find a gun. Is that two separate crimes? There's just so much ambiguity. I think you're going to have problems even prosecuting it. Meanwhile, back at the ranch, you're going to have a whole bunch more people in your jail, and defense lawyers are going to have a field day. I also think that it's in the wrong section, right, with the rail car, because we're having a whole conversation about rail cars. I mean, if we want to enhance punishment for something, you can have a whole section just on this particular crime where you enhance it. So now people are confused. Former sheriff, now Rep. Louderback, my new best friend, is talking about cars getting stolen out of rail cars. And they're either new or they're not new and stuff. So it's just confusing. And I think the best way to get the bad guys, and notwithstanding the fact that I'm a criminal defense lawyer, because some people need to be put under the jail.
Sure.
Right? But people also have a constitutional right. And I just think that the road to hell is paved with good intentions. So I think there needs to be a more narrowly construed law so that when someone does do what you're trying to prevent, that it's a much easier proposition for the prosecuting attorney to actually nail them for the intent and a decision to keep a gun, and they knew there was a gun, and then to go on and terrorize the neighborhood. And I don't know if I helped you understand.
I'm certainly open to I just would love to be the opportunity to be a part of that conversation moving forward. If it does come to the putting it somewhere else or changing up wording, I'm certainly, I always welcome the opportunity to do that, absolutely. Yes, ma'am.
Ms. Rodriguez Ramos.
Thank you, Mr. Chairman. And I'm, to piggyback off of Representative Jones, when you read this section, the way the law is written, it says the actor broke into or entered a vehicle, possessed a firearm, committed theft, used a stolen vehicle, or committed the offense with respect. And it was a third degree. So the way it reads, I could have done any of those, not all of them together.
Right.
And so that's what you want. You
Yeah.
want any single one of those for them to be, and not break into and possess a firearm and committed theft?
For example, if they did all of the above, I'm not saying we charge them with 4 felonies. I'm saying we charge them with whichever one, again, is the strongest case that we have to prove up.
So the idea is pick one of those and it be, the offense be a third degree felony?
And any one of those by themselves would trigger this offense.
Okay, thank you.
Yes, ma'am.
Anything else, members? Sheriff, one other thing I need to just clean up. Your affirmation indicates that you're testifying for yourself individually and as Bexar County Sheriff. Is that correct?
Yes, sir.
Okay, that's perfect. Okay. We really appreciate your motivation in this bill, and we appreciate you being here today, and we'll continue to work on the issue.
Thank you so much for the opportunity. I appreciate
you.
it. Be safe. God bless.
Members, our next witness is Kathy Mitchell. And once again, when you come up, Ms. Mitchell, if you'll identify yourself, who you're here before, it indicates equity, action, and self, and that you're against the bill. If you'll just affirm
sir.
that for me.
Yes, sir.
Thank you.
So thank you all so much for that dialogue about the bill. It will shorten my testimony. People caught burglarizing vehicles are routinely charged with primarily felony organized criminal activity. That is the charge that arises most often when more than one person is involved in opening a door. So we're talking about the gun-free zone now. Open a door, look in, steal something or don't, but if you do it with another person and you have an intent to, say, steal credit cards, you can be charged with organized criminal activity. We passed 5 versions of that statutory change last session, and it's a little complicated to tease it out, but it does appear to be the most common charge used for burglary of a vehicle, and it is already a felony. Of course, as you've discussed, possession of a stolen firearm is also a felony. So you don't have to have stolen the firearm, you just have to be in possession of it. And that is also a state jail felony. In my view, increasing this charge to a state jail felony will have no impact on the prosecution of serious criminal organizations who are out there stealing guns out of cars, because we already have felonies for that. What we don't have a felony for is the teenage girl who decides to open a car door and peek her head in and then go to the next one and peek her head in and may or may not steal anything of great value, but she gets caught. So this bill is only going to newly felonize the very lowest level property crimes that involve opening a car door, looking in, and rifling around. I have, like most of us, experienced having my truck door opened in front of my house and somebody rifled through. I do not keep a lot in my car for that reason. But I don't want the likely teenager who did that to end up with a felony charge. We have existing statutes that are already in place. You all have discussed them at length. I want to add one more thing here. The lack of felonies is not the reason why we continue to all experience people rifling through our car. It's really about enforcement. And I just want to remind people that we in Texas created the Motor Vehicle Crime Prevention Authority back in the 2000s, I believe. And this is where we invest money as a state in the kind of investigations that actually catch the organized criminal activity that we're most concerned about. So if we want to walk down that road and decrease the amount of that, we can do so by increasing our investment in this. So I just want to say, you know, this is a problem that purports to solve one thing, actually does something else, and neither of them will reduce the amount of burglary of a vehicle in our communities. And I'm happy to answer questions.
you.
I come loaded for bear.
Thank you, Ms. Mitchell. Any questions, members? Mr. Little?
What is Equity Action?
We're an Austin nonprofit that works on criminal justice issues.
And what's the mission of that organization?
Justice transformation, we're trying to ensure that our justice system gets to the right solution as opposed to just the most punitive solution.
Yeah. I think I understood your testimony, but I don't understand how this proposed statute from Representative Guerra would address the situation of a teenage girl rifling through a car, unless she happened to rifle through it with a firearm, or
No,
rifle through it and
it's-
hold on a sec, just 1 second.
Yes, I can
Or
answer
rifle
that.
through it and obtained a firearm and then left the vehicle.
It
So-
has the fourth provision, and it's a list of items. The fourth one is 2 vehicles. So if that teenage girl went down the block and opened 3 vehicles on my street, regardless of what she stole, she will have committed that 4th crime of multiple acts.
Well, this is another problem that I have with the statute is you're talking about subsection 5, Romanet 5, committed the offense with respect to 2 or more vehicles during the same criminal transaction. What is the offense?
Burglary of a vehicle. That's how I interpret it. But, you know, again, you all have pointed out that there's a lot of confusing structure in this. So I've interpreted it to mean that that teenage girl who went down the block and opened 3 doors would have violated that final provision. The rest of those provisions articulate acts that are already felonies.
So what you're saying, and I'm not sure that you're wrong, okay? What you're saying is each one of these Romanettes that is included in subsection capital B, the actor broke into or entered a vehicle or part of the vehicle, the actor, and there's Romanettes 1 through 5. Each one of those is an independent offense.
That's how I interpret this bill, yes.
And so the moment you enter the second vehicle with the intent to steal anything irrespective of a firearm, you've now committed a state
Yes,
jail.
that is how I interpret it, and again, you all have pointed out that it is a bit confusing.
Thank you.
Ms. Jones?
I love the intellectual jousting here. It's like making me happy. As to what you say, Rep. Little, you don't have to intend to steal anything in the car. Literally, BMV, burglary of a motor vehicle, is you just have to intend to enter the car, right?
Correct.
So you don't have to steal anything. A BMV is sort of like a shoplifting. You may not get away with the stolen stuff. Once you cross the last point of sale, the shoplifting is complete. I mean, period. So I just think that we have to anticipate the unintended consequences of any law we pass and make sure that whatever law we pass addresses the problem and doesn't create a whole bunch of other problems. And again, criminal defense is a lot of what I've done for 30 years, and I would have a field day. I would hope, wish, and pray that every single solitary one of my clients was charged with this, because all I have to do is create reasonable doubt as to one element of it. I think we can get to where we want to get to address the issue, although I do believe that what the sheriff is trying to address is already addressed in the law. The ambiguity in this bill, I think, is fatal, at least for me. But we can work on it, because my car's been broken into in front of my house, and I was salty when I woke up and I had to pay money to fix my car, and I had nothing but change in there. So, anyway.
Any other questions?
I have a question.
Ms. Ms. Rodriguez Ramos.
Thank you. In your research, and I'm looking at thank you for citing the Motor Vehicle Crime Prevention Authority. And they, I guess, come out with an annual report, and so they did cite that there's been a significant, well, the last one I think is 2023, there was a decline. But in your research, is there been any, or are you aware of any penalties for the actual gun owner who is being negligent and leaving his firearm in the car versus increasing other penalties? I mean, we would reduce firearm thefts if we reduce the availability and accessibility of firearms. Have you seen any, seen
I
any
am not
research?
apprised on that front. I'm sorry.
Okay. Oh, no, no problem, no problem. Thank you so much, and I appreciate your testimony.
Thank you.
Anything else? We appreciate very much you being here. Thank you. We have one more witness signed up, and that would be Mandy Zapata with the Texas, and I hope I pronounced that right, Texas Civil Rights Project, and on behalf of yourself. If you'll go ahead and identify yourself, and you've registered against the bill.
Yes, I did. My name is Mandy Zapata, and I am with the Texas Civil Rights Project, and I'm representing myself as well. I am against the bill. And for all of the reasons that kind of were already brought up and mentioned today, but I also want to speak more broadly about the juvenile justice perspective, about how criminal enhancements, it doesn't really prevent or cause a solution, especially when it comes to vehicle-related burglary or theft. Enhancements don't deter it, especially the youth, and if you look at the data of the burglaries when it comes to vehicles, the statistics show that they are commonly committed by teenagers and young adults, but it's driven by poverty, addiction, or peer pressure. Let's be clear that the juvenile justice system in Texas is already overburdened, and so is TDCJ. We face severe staff shortages, and even the Sunset Commission has recommended closing TDCJ units. Due to the system's inability to manage its own current populations, police and courts are stretched thin, dealing with violent and high-priority cases. Diverting resources to punish young people for petty offenses only make our communities less safe. I understand that nobody wants their car broken into or anything stolen from their stuff. I just also want to be mindful that if we're going to start enhancing misdemeanors to felonies, that's a life-changing offense, because felonies go with you throughout your life and they can prevent you from having housing, job opportunities, and if it's young adults and juveniles that it's affecting, you're basically making a decision for the rest of their life instead of giving them the opportunity for rehabilitation, which is our goal in Texas for juveniles. Thank you.
Thank you for being here. Any questions for Ms. Zapata? Thank you very much. Is there anyone else here to testify for or against House Bill 727? There being no one, Mr. Cortez, would you like to close?
Yes, Chairman. As I told you, members, this is an easy bill. And I would like to send it to local and consent if possible, Chairman. So that's just a simple request. Maybe we can vote it out today. That'd be great. Members, I appreciate all the comments. I appreciate the dialogue. You know, we will work with Ledge Council to try to get a committee substitute going to get some additional language in so that we can tighten it up and come back before you and continue this discussion. And I appreciate the sheriff. I know he had to step out for making the way up here to Bexar County. I know his intent. He's trying to improve the safety of our communities and improve the safety of our families. And I appreciate him working with my office to try to do that. And so we'll continue working on this bill, Chairman, and then we'll get back to the committee.
You might, and I know you'll do this, but just work with some of the committee members who voiced some issues, not necessarily opposition to the bill, and try to deal with those. Any other questions for Mr. Cortez? Ms. Bowers?
Thank you, Chairman Smithy, and thank you, committee members. Thank you, Representative Cortez, for your hard work on this bill.
It's Guerra.
Oh, yeah, that's what I was trying to make clear, that it is Representative Cortez that has presented this bill to our committee. But I am not, like my colleague, a 30-year criminal defense attorney, and it does seem pretty simple to me with, I've not been a sheriff or anything like that. that certainly what you are trying to do is to make your community more safe. And so
That is the goal.
I just want to, that's why I appreciate you saying it's an easy bill. I do appreciate y'all's dialogue and what I heard from those attorneys that are on the dais here, but I hope that we can, find some solutions in getting it cleaned up if need be. But I want to just thank you for your hard work.
Thank you, Representative Bowers. And I'm a strong supporter of law enforcement. I'm proudly supported by them in my community. And so anytime the sheriff or police chief or anyone in law enforcement comes to me and says, we have a problem, this needs to be addressed, it's putting my officers in danger, my sheriffs and deputy sheriffs in danger, I'm going to try to do my best to take action. And this is what this process is about, to try to find the language that can help do that. And so I appreciate all the comments and the dialogue, because we'll get there to where we need to be. We will continue to work on that.
We always do.
I'm sorry, I didn't mean.
Not at all, Mr. Chairman. I was really about finished, but yeah, we always get there. So thank you. Thank you for bringing this bill, and thank you, Mr. Chairman, for calling it up.
Mr. Little.
Representative Cortez, sorry, my mistake from earlier. My
It's
warmest
okay, Representative Cook, it's fine.
My sincerest apologies. I think I would be inclined to be supportive of a narrower bill that deals with the use of or theft of a firearm in the course of the burglary of a vehicle, because I will say that I've had a firearm stolen from my vehicle before. They're very difficult to recover, and once they're in the wind, they're kind of in the wind. If Sheriff Salazar were to happen to catch someone in the middle of an offense stealing a firearm or in the use of a firearm, I absolutely think that should be a felony. And so perhaps a more narrow bill crafted slightly differently would achieve the intended result.
Yes, sir.
Thank you.
Thank you.
And, just in the last few days, we've seen several instances of car burglaries in place, and the owner or even a bystander coming out and trying to, object or stop it, and there's a shooting as a result of it. So it's a very real problem.
Yes, sir.
Any other questions, members?
Thank you very much.
Mr. Wu has one.
Just one quick comment. But at the same time, I think it's important, as the sheriff said, let's take an all-around approach. I mean, we're sitting in approach talking about some of this stuff, and if there's things we can do, if the state can do to help local communities, like, hey, we can help in education, we can help enforcement, whatever it is, let's have that conversation and tell
Absolutely.
the sheriff, like, please come on back and we'll have these conversations.
And we'll do that, Mr. Vice Chair.
Mr. Loudback?
Thank you very much for the kind comments. And burglary of a motor vehicle and thefts and weapons are a major part of what we find in law enforcement every day. We find them in all sorts of places, and they come out of vehicles. So appreciate you bringing it forward.
Yes, sir.
Thank you.
Thank you, Representative.
And for those of you who don't know, Representative Louderback has a background as a sheriff, so in law enforcement
Thank
for a
you for your
number of
service,
years.
sir.
So he has an understanding of these issues that many of us don't have. Mr. Cook?
Thank you, Chairman. Mr. Cortez, I like the bill as it's written. I think it is very clear, straightforward.
Thank you,
I think
Chairman.
Only, B1 deals with the rail car. The rest of it doesn't deal with the rail car as I read it. I think it's straightforward and would support the bill.
Thank you, Chairman.
Okay. Anything else? Well, with that, we're going to obviously leave all the bills today pending. We've got some time to look at them and get them out. So we will, if there's no objection, the chair will leave House Bill 727 pending. And we
Thank you,
appreciate you being here.
Thank y'all very much.
Okay, thanks.
Thank you.
Fellas, I've got, Representative Hayes came in at the first. Can I go ahead and get him? Is that okay? The chair would recognize Representative Hayes. And the chair would lay out, to lay out and explain House Bill 305.
Yes, thank you, Chairman and members. My bill deals with burglary of a vehicle with a briefcase. Now,
And we have a committee sub,
Yes,
and so
you
Mr. Wu will lay out the committee sub to House Bill 305.
thank you. Hope you each have a committee sub. If you do not have that, then the clerk has those for you. When a criminal court deems a defendant incompetent to stand trial, the court orders the defendant to be committed to a state hospital or qualifying mental health facility for competency restoration services. Currently, the Health and Human Services Commission is experiencing a severe staffing shortage, causing 288 of their 2,329 beds to be offline. You know, it's over 10%. As a result, only about 87% of their beds are online. In December 24, the wait list for an available forensic bed is over 1,741 individuals with an average wait time of 241 days. Now, that's like 8 months. So what we're doing is we're waiting 8 months to get someone into a facility. And then what this bill does with is once competency is restored, the defendant is returned to the court for adjudication. Unfortunately, due to court backlog and delays, some defendants fall back into an incompetent status while in jail waiting for pretrial hearings. If not processed in a timely manner, defendants can find themselves in a revolving door of incompetency, exacerbating the already dire forensic bed waitlist crisis. So this bill addresses this concern by establishing a reasonable time frame for defendants who have competency restored to a 14-day pretrial hearing upon their return to the county. Thank you, Chairman and members, and I believe we have witnesses, so I yield for witness testimony and reserve my right to close.
Any questions for Mr. Hayes? Mr. Little?
Yeah, Representative Hayes, just a quick question. If your bill passes and we modify the Code of Criminal Procedure, what is the remedy if that hearing is not conducted within 14 days?
Yeah, the bill is silent as to there's no criminal penalty, there's no civil penalty. It's really going to be within the court's discretion, I guess, to
Like,
be the best answer I could think of.
Does a defendant have the right to move for dismissal of the charges on the basis of the hearing not having been conducted within 14 days?
The bill doesn't address that specifically.
Okay. Just a quick question, another quick question for you. So, can you give me a sense of the average wait time for an individual who's deemed incompetent to stand trial to get into a state hospital bed?
Yeah, that's the 241 days.
241?
Yeah, the
So-
court's determined them incompetent. Now they're going to send them off to either a state facility or a private facility, and the average wait time is 241 days.
Wait time in the jail, you mean?
Yes.
Thank you, Mr. Hayes.
Yep.
Any other questions for the author? Oh, Ms. Rodriguez-Ramos.
Thank you, Mr. Chairman. Is this issue more common in the smaller counties or the urban areas in terms of the longer wait times?
The data I've seen is it's pretty much uniform because there's only so many forensic beds available. So whether you're in a big county or a small county, now statistically you're going to have more offenses created in larger counties, so I would expect there to be more. But whether you're going to San Antonio or Rusk or Wichita Falls, every county does not have a facility.
Mm-hmm. So does every county have a criminal court specifically for criminal, or do some counties, judges, smaller counties have, do their courts do both criminal and civil?
That would be accurate. That is, some counties, the larger counties, have county criminal courts at law. There's a judge here today from a county criminal court at law.
Mm-hmm.
But many counties have not elevated yet to the fact that they have a designated statutory county court at law.
So I'm wondering, in the smaller counties, I represent a larger county, but I know the rural areas, our smaller counties, are sometimes getting the short end of the stick in a lot of spaces, and my concern would be in the smaller counties, they'd not be able to do this within the 14-day time frame because they don't have those dedicated criminal courts. Have you had conversations with some of the smaller county courts to see, or what those judges have expressed to you, their ability to actually expedite the hearing, the pretrial hearing?
Yes, ma'am. I've talked to a number of judges and a number of counties, and what this really does is create docket priority. I mean, they're going to already be in the court or sitting as a judge. So this elevates it past other normal day in and day out docket items, because the challenge is if you don't get a quick hearing and then they go off their meds, then they have to return back to the state, and then you have that waiting period, which is exacerbating the wait times that I talked about earlier.
Yes, sir. Thank you.
Any questions? Mr. Louderback?
Representative Hayes, let me clarify something for you that we see as a real problem here. And actually, Representative Jones and I have talked about this very thing. And when competency restoration is restored and they're sent back to the counties, and then it could be a lengthy time before they're brought before the court again. And at that time, the competency restoration that we invested so heavily in our state is actually lost.
Correct.
For one reason or another, and you're trying to decrease the time and make them get to a competent judge earlier.
Yes, sir.
Thank you.
Anything else? Ms. Jones?
Again, my new best friend, Rep. Lauterbach, so I filed a bill that seeks to try to do the same thing, right? So there are a variety of reasons why when they get back, they may fall back into it. Sometimes it's because they refuse to take meds, right? And the local sheriffs can't force them to take meds. Sometimes the local sheriff's department won't give them the meds that the state facility determined worked, right? So it's just there are a whole bunch of problems. And I think that in a large county like Harris County, which is obviously where I represent, is that we've got inmates in other places. We under orders that we have jail overcrowding. So sometimes we got to yank people back from Louisiana or wherever we ship them off to. I'm saying we because I'm the government. I don't think we should do that, but we do. You can only have so many people back in the holdover, otherwise you'll have to pay fines. And so I think that 14 days is very quick. We don't even have hearings because the dockets, so for example, I'll have a case today, and when I leave court today, I will know that my client is reset, I don't know, maybe a month from now. So those dockets are already established, and to try to force somebody in causes a problem. So I think there are a lot of logistical problems related to it, but I was actually going to ask the question that Rep. Little asked, what's the remedy? You say do it in 14 days. How do you make people do stuff is my question.
If I may, someone else in the room suggested that mandamus would be the remedy. That's cold comfort to someone who's sitting in a jail. Mandamus, even when expedited. So,
And I understand that, but then that's more administrative work that they have to do.
hire a
Right.
lawyer to do.
Right. So I have the exact same concern as you. And I think you said it was 281 days. I don't remember the amount of days. We literally have people in Harris County Jail that have been there for years.
Well,
Regarding competency. And the problem for me, say if they've fallen back into incompetency, I literally don't know which one of my clients is going to show up. You heard that movie Sybil, right? They might be hearing voices, and then they literally can't help me defend them. And then I wonder what's the value of having a hearing when my client can't help me. So I think I don't know what the answer is. If it were easy, it wouldn't be a problem. And former Sheriff Lauterbach and I probably spoke about this for over an hour, just trying to figure this out. So maybe the three of us to try to put our heads together to figure out something else he made me aware of that I didn't know. You send an incompetent person off to the state facility, they figure out the drug combination that gets them back to competency, and then they send them back to the originating county, and then the medical provider there is like, well, no, I don't agree with that. Right? So I'm not giving this defendant that. Or the meds cost too much money, although we don't think that should be an excuse. So what do you do when you have two conflicting diagnoses, like who are you going to roll with? So then you have those problems. So I'm just trying to figure it out.
I think it's a complex problem. There are many stages where it can go off the rails. My bill doesn't try to seek to address every one of those. It takes one of the most important. The reason you have a committee sub, my original bill is filed, was 30 days. And as I talked with members of the judiciary, it was at their behest that it was moved to the 14 days to try to prevent the problem of them getting off their meds or going back to a state of incompetency to keep that process moving forward.
Do we have any of those witnesses here, the members of the judiciary that you spoke with? That might
there-
be helpful to hear what they have to say.
There is, I know, one judge here today, and
We
I'm.
have a
to be-
judge who's signed an affirmation, yeah.
To be fair, I don't, I talked to some of the judges, I can't blame it on him, on the recommendation of the 14 days. Thank you.
Okay, anything else?
Mr. One more question. I'm looking at your committee sub, and if you start with the underlined portion, it says, except that in a jurisdiction to which subsection D1 applies. And I'm not sure jurisdiction is the right word there. It may be, it may be criminal matter, or it may be, I'm hung up on that word jurisdiction, as if you generally refer to a jurisdiction as a place or a court having subject matter jurisdiction or jurisdiction over a person. I understand what it's trying to accomplish. If you look at D1, it deals with D1, not your D-1, but D1, it deals with competency. I'm just kind of hung up on that word. And if you have the ability to explain it to me, great. If not, maybe someone else on the committee does.
Well, D1 says, this article does not require the criminal case to be finally resolved with any specific time period, is what D1 starts off. And so.
D-1.
Yes.
Yeah.
And so I think what they're trying to do is know that even though we're putting a time period for the pretrial hearing to be 14 days, we're not saying you have to adjudicate the entire case within 14 days. That's how I read it.
Except that D1, not D-1, as Representative Little points out, which you may not have in front of you. But D1 says that if the defendant is found competent to stand trial on the court's own motion, criminal proceedings shall be resumed not later than the 14th day. So it looks to me like there's already a provision that says if the court decides, then it will resume within 14 days. And this D-1 is saying not counting those kinds of cases.
Yeah.
If there still needs to be evidentiary or procedural issues, they have to start within 14 days as well. But I think it should be, to Representative Little's point, except that in a case or
Kind of
matter.
circumstance or something along those lines.
Thank you, Representative Money, because I did read the wrong D.
Yep.
Yeah.
I need the record to reflect that Representative Money is present.
Oh, thank you.
Initially, neglected to do that. Any other question or comment? Mr. Wu?
Richard, I think your intent on this is very clear. I think there's ways we can just clean up the language and fix and do what you need to do. I think that's easy
Thank you.
fix.
Okay. Thank you, Mr. Hayes. Give me 1 second. Okay, we have Chance Oliver, Judge Chance Oliver from, doesn't tell me what county, but you're in Representative Little's district, which I presume is Denton County, yes?
Denton County, that's correct. Good morning, Chairman, committee members. My name is Chance Oliver, and I'm here to express my support for House Bill 305. I'm currently the judge of County Criminal Court Number 4 in Denton County, Texas. I'm also president of the County Court of Law Association, Judges Association. Before that, I've been doing this for 7 years. Before that, I was a prosecutor. I was a defense attorney, been a civil lawyer, and before that, a prison guard. So I've got a wide array of experience in that in this regard. So in my current role, I supervise actually a jail diversion grant where my diversion coordinator and I work hand in hand with the probate court to divert low-level offenders from jail to treatment. It's through this experience that I've become acutely aware of the mental health crisis our country is facing. Every day we are confronted with the challenges of a lack of state beds and insufficient jail competency restoration options. I know you're aware of the crisis, so I'll focus specifically on House Bill 305. I support this bill because it establishes a hard deadline for conducting a pretrial hearing upon competency restoration. I assure you that my colleagues also support this initiative, is we believe that 14 days is more than enough time to bring the offender to court to determine the next steps, whether that involves a plea or a trial. And I was one of the ones that mentioned 30 days is way too long, in my opinion, because as Representative Jones stated, sometimes the meds, they send them back generally with 30 days meds. And the quicker you get them done, because just like in Houston, I'm from Houston, I live in North Texas now, but just like in Denton, they often prescribe different meds as well. So I think it's very important. In Denton, our goal is to have the offender back in court within 1 to 3 days to determine what the next step's going to be. And that's facilitated by advance notice from the treatment facility prior to their transport back to Denton. So they have a heads up. It's not like they just appear one day in court and you have to put them on your docket. So I believe most judges will have no issue adhering to the new deadline. It will force primarily the teeth you're talking about. I think it will force the DA and the defense to do their jobs more timely. And that's what you find in many of these circumstances, like Representative Jones said, you go down there and you don't know which one of your clients is going to be there. But if you know they're just got back, you're eager as a defense lawyer, in my experience of that, get this done as fast as I can. And what this pretrial hearing within 14 days, oftentimes that's going to turn into a disposition hearing or a plea bargain in most cases, especially if they've been in state jail waiting for hundreds of days and in the state jail regaining competency for hundreds of days. The likelihood that they'll have a time served offer, especially given their mental health diagnosis, is very common. So they're eager to resolve these. We all recognize the substantial costs associated with holding inmates in the county jail, which can be significantly higher for those with mental health diagnosis. My sheriff tells us 3 times as costly is what it takes to hold them in county jail. Expediting these is beneficial to the offender, the courts, the victims, their families, and the jail system. And I appreciate you guys for taking this important step. And having dealt with mental illness in my family and witnessed the impact in my court firsthand, I understand it's one of the toughest aspects of my job. It's the worst or the hardest part of the work I do on a daily basis. It's weekly, but I have this mental health hearings, but it's very difficult. And I believe mental health's high on the charts here in Austin and in Denton County and I'm grateful that we're continually taking steps to address the issue. And there's no definitive playbook that says this is how you fix everything. We're learning as we go, and all we can do is try to get better every day. So I appreciate the small role I'm playing in exploring new and innovative ideas to help Texas lead the nation in mental health treatment. I thank the committee for doing everything possible that you guys can do to further this goal. And thank you, Chairman, committee members, and if I'm here for any questions, and I believe I could answer some of the ones that you proposed earlier, if you have any.
Judge, thank you for coming down from Denton County. We're glad you're here. Any questions for the judge? Mr. Little?
Judge Oliver, just first of all, as your state rep, I just want to extend our warmest possible congratulations and thank you for being here to talk to us about this very important bill. Your sacrifice and service to the state of Texas is certainly accomplished. And I thank you for being here. Just a couple of quick questions. Do you have a copy of Representative Hayes' committee sub?
I have the original one, and I know the sub, yes.
Okay. Is jurisdiction the right word there? Should it be that word or a different word?
I heard that question, and I don't really know the answer to that, but okay. I think there is a concern that that could be changed. Oh.
Thank you, Representative Wu. And second question I have for Your Honor is, what really is the remedy if prosecutor doesn't bring them to court within 14 days? I mean, is it mandamus? Is it dismissal? What do you think it should be, and how should we address this problem?
And I know that in some courts, in some counties, the courts control their docket, right? And as a judge, we control our docket, but there's counties, and especially felony courts, where the DAs, like you say, control the docket. And they'll get them to court when they want to get them to court and not necessarily judges. That's very common that I've seen. So the remedy, I don't know that there has to be a remedy. I mean, I guess there always should be. But in a case like this, I think it allows a judge to hold the DA and the defense attorney's feet to the fire because they're saying the code requires me to do this within 14 days. So I am going to do this within 14 days because this is what I'm required to do so you're going to make it happen.
This is certainly not a problem in your Honor's Court or in our courts in Denton County, but in other counties, I can imagine a situation where a district attorney would say, I'll bring them when I feel like it. And we need, I'm questioning what the remedy is for a defendant to whom this process is not being rigorously applied.
And I can only say that I believe that even a DA who doesn't want to do their work on a daily basis will want to get this case resolved, because it's a person with mental health diagnosis and they realize how difficult it is. And I believe that they would be committed to getting this one done, if nothing else.
Thank you, Judge Oliver, for your time.
Any other questions? Mr. Wu?
Thank you for being here, Your Honor. I'm going to ask you some leading questions. Okay. I think maybe if I can help summarize what you're saying is, because pretty much judges across a state understand how big of a deal this is, and for counties, this is such a huge money sink and such a huge problem for their finances, that this is something that everyone's paying very close attention to, correct?
Correct.
Right? And even though, like, the provision may not have a what if provision, most judges and prosecutors and people who work in the system would see this as a very clear legislative intent directive to them. And no matter how recalcitrant or how stubborn a DA might be or a judge might be, they still don't want to have the state come and say, hey, you clearly do not follow the black letter of the law, right? There's no penalty for it, but it's just, that's embarrassing, right? That you can't follow black letter law. And I think what you're saying is that even without a punitive provision in this, because everyone knows how important it is, and because people wouldn't want to be seen just like flouting this because everyone else is, what are you doing, right? That people will obey this, and this is enough direction to all the judges and prosecutors in the state that they will do what's required in this without a stick.
Right, I agree with that. And if you read this section of the codes that we're talking about here, 46B, there's a lot of timelines and provisions that don't say this is what happens if you don't do it.
Any other, Mr. Money?
Yeah, I would just say that throughout, I'm not as familiar with the criminal procedure, but throughout the civil procedure code as well, there's a lot of rules that courts follow and the parties follow, and there's not a explicit provision on what happens if they don't. So that part of it, I think, is less concerning, and I do appreciate the testimony of that this is the kind of case that judges want to move along, and I think that's in the best interest of everybody.
Okay. Any other questions for the judge? Ms. Jones?
Thank you, Mr. Chair. I also see, even with the change of DAs in Harris County, the DAs is trying to get cases off their docket, especially the low-hanging fruit cases. The judges want to decrease their dockets, right? Because they were like high because of the previous DA. And I find the prosecutors to be way more reasonable now. So I think that even without the stick, although sometimes I like to see sticks, that there is an encouragement to resolve the cases. And certainly it's going to save money, I believe, which I know that jails on a regular worry about their budgets because they're relying upon commissioner courts to sufficiently fund them, and most times they're not sufficiently funded. And I also see that a lot of people who are incarcerated, the magic word is time served. And if you can get them time served, then it's like, okay, Ms. Jones, I'll sign. So I think that I'm thankful that my colleague filed the bill. I hope 14 days later my clients are competent still. That's wishful thinking. But I understand why it was filed, and I understand what we're trying to do. And we'll just make sure that it's written in such a way that we get there.
Yeah. Any other questions? Judge, thank you for being here.
Thank you all. Thank you very much, Chairman.
We have Lisette Galvin from NAMI, Texas, who is registered in favor of the bill. And once again, if you'll identify yourself and who you're here.
Yes, sir. Good morning, Chair Smithy and members of the committee. My name is Lisette Galvan, and I serve as the Public Policy Director for NAMI Texas, which is a Texas affiliate of the National Alliance on Mental Illness. We represent nearly 1,700 families and individuals living with mental illness in our state. I am here testifying in support of House Bill 305 and its committee substitute, which aims to reduce the time individuals with mental illness spend in county jails after competency restoration. Texas continues to struggle with a growing forensic waitlist crisis, leaving individuals with mental illness stuck in jails while waiting for competency restoration. According to the Texas State Auditor's Office report from November 2024, approximately 341 individuals who were found competent and returned to county jails, decompensated, and were again found incompetent, restarting the cycle. Decompensation occurs when an individual's competency is restored, but delays in trial proceedings cause their mental health to deteriorate, requiring recommitment for competency restoration and placement back on the wait list. As a result, the 341 individuals placed on the wait list multiple times, ranging from 2 to 6 times for the same charges. This is unacceptable and highlights the urgent need for reform. Committee Sub HB 305 offers a practical solution by requiring a pretrial hearing to be set within 14 days of an individual's return from a state hospital to county jail. This change is critical to preventing individuals from undergoing prolonged stays in jails and decompensation, which can erase any progress made in treatment and further delay justice. By ensuring a timely pretrial hearing, Committee Sub HB 305 helps reduce the likelihood of individuals cycling back into incompetency, alleviate strain on our overcrowded state hospitals and county jails, and upholds the dignity and rights of those living with mental illness. I urge you to support House Bill 305 and its committee sub to ensure Texans with mental illness receive the care and timely justice they deserve. Thank you for your time and consideration.
Thank you, Ms. Galvin. Any questions or comments? Ms. Bowers?
Thank you, Chairman Smithy, and thank you for your testimony from NAMI. I really do appreciate that because some of my questions did deal with, if there was anything that the representative had heard from judges or mental health professionals. So thank you for being here.
Thank you, Rep. Bowers.
Anything else? If not, we appreciate very much your being here in support of the bill. Oh, Mr. Money?
I'm sorry, my questions are for her.
Okay.
Thank you, Chair.
And next we have Melanie Billingsley with the Texas Jail Project and herself, on behalf of herself. Once. So once again, if you'll identify yourself and your position on the bill.
Hi. Let me get my readers on. My name is Melanie Billingsley. Good afternoon, Chair,
Ms.
Vice
If you would prefer, either way is fine. If you would prefer to sit, you can move that microphone a little closer to you
Thank
and
you. I
adjust it.
appreciate
Either
that.
way is good.
Right. Okay. My name is Melanie Billingsley, and I'm here to speak for HB 305. I'm for it. Today marks the 8-year anniversary of my mother's death and my son's arrest in Harris County. My son is 29 years old now. He was diagnosed with schizophrenia at a young age, and we struggled for years to find appropriate help for him. 2 years after his arrest in 2019, he was found incompetent to stand trial. It took almost another year before he was transferred to Vernon State Hospital in June of 2020 for competency restoration. He spent 9 months in Vernon. When he was brought back to Harris County Jail in March of 2021, it was like a miracle. The medicine made a difference because he was almost stable and almost normal, but that didn't last long. His medications were changed. because the jail formulary was different from the state hospital formulary. And soon he began to deteriorate. He went through multiple competency evaluations and forced medications through court orders. He was found incompetent to stand trial again in August of 2022. It took them until February of 2024 to send him back to the state hospital. This time he was sent back to Vernon for civil commitment pending criminal charges. 2 years later, in August of 2024, Vernon State Hospital deemed him competent, and he was sent back to Harris County Jail in September of 2024. I cannot even begin to express how inhumane and brutal this repeated cycle of deterioration and restoration has been on my son and our entire family. We are all stuck in this loop together. Feels like purgatory, only worse. We are all victims in this situation. This entire saga has taken a huge toll, not only on my son's physical health, but also our families. According to data from Texas Commission on Jail Standards, in the 8 long years that my son has been incarcerated, 121 people have reportedly died in custody in Harris County Jail. A majority of them pre-trial. People with serious mental illness are the most vulnerable population in jail. They can't fight back for themselves. I believe stipulating strict timelines for hearings after competency restoration would not only save enormous resources in a system that is already overburdened, but will also mitigate the suffering for victims and defendants who are legally innocent. I implore this committee to vote yes for HB 305. And I do have a comment, if I may, towards the remedy for maybe pretrial hearings. It was said to me that maybe pretrial hearings can take place at the hospital before they leave, because it is the time in the jail that they sit waiting, that they deteriorate. At the hospital, they can do video hearings and remain on the medication without lapse. That is important. That medication makes a difference.
Okay, I appreciate you coming with your testimony, and I'll ask if there are any questions. Ms. Jones?
I don't know that I have a question, but I was just thinking about that because I do Zoom hearings now that I'm in the middle of the legislature since I can't go back to Harris County when I'm here. I was just saying to my colleague, Vice Chair Wu, because we both do, we're in the criminal arena, like, how does that work? How do we get to Vernon? And then when you said Zoom, it's like the answer magically just popped up. We can do that. The question I would guess would have is maybe should look into it, is if they have the capacity at the mental health at Vernon to do it, is the question. Would they have a judge? I mean, if the judge could Zoom in.
I know I've Zoomed in with my son there, so they do have Zoom capacity.
So anyway, but yeah, I actually think that's a good idea.
Okay. Any questions? Okay, we sorry for your experience, and we appreciate you being here.
Thank you for your time.
Thank you very much. Members, that concludes our witnesses for and against, but we do have as a resource witness Brandon Wood with the Texas Commission on Jail Standards. Mr. Wood, if you have any testimony you'd like to give, or if you're just here for questions, either one, we appreciate you being here. Mr. Wood, do you have any comments or suggestions on the bill before we open it up? Or?
Brandon Wood, Executive Director, Texas Commission on Jail Standards. Again, I am.
And you're testifying on the bill?
Yes, sir.
Okay.
Neutral on the bill, serve as a resource. I was asked if we had experienced any issues in regards to individuals that had returned to county jails, lost competency after having it restored and having to be sent again. And just as a matter of fact, yesterday afternoon, I was speaking with Anderson County officials, and they are experiencing an individual in which that person has been incarcerated in the county jail for 4 years. They've been sent for competency restoration twice, and they have concerns about how much longer this will go on. County jails and mental health issues, it's often cited as the most challenging issue that they do face by sheriffs all across the state. and therefore any attempt to address this and reduce this issue would be much appreciated by the county jails, of course.
Any questions? Thank you, Mr. Wood.
Thank you. Just not quite related to this, exactly on point with this bill, but like, would you be able to tell the legislature which scenarios, which patients that come in that this most frequently happens for? Like, because I had a client, a juvenile client that had schizophrenia, the exact same thing. Goes to the state facility. They're on meds. They're on therapy. They're back down to where we found them competent, but over the next 6, 8, 9, 12 months, their compensation is going lower and lower, and they're having to increase their med dosage, and then they're refusing to take their med dosage because it's getting higher, and like that the story that the previous witness said is something I think is pretty common. Are there other types of patients, like depending on what kind of mental health issues they have? Can we like define like a list of these are the ones who we have the most problems with? Like, so like I'm talking about if we can find a strategy to deal specifically with those and the other types of mental health issues that we can address and they don't decompensate later on and we'll have to worry about them as much. That kind of information I think would be really helpful, not just to this committee, probably for like appropriations and other stuff as well.
That is not a data point that we currently track, but I believe that there could be value in that because you would be prioritizing
You understand what I'm
these.
trying to
Yes,
get at,
sir.
right?
Absolutely.
Yeah.
So I think that would be a joint effort. We would need to collect the data, the names, and then look at those individuals. So that would be something we could look at.
Yeah, so instead of trying to fix this with a sledgehammer, we should go in with a scalpel and figure out what things need to be changed to what.
Yes, sir, the prioritization.
Thank you.
Yes, sir.
Any other questions? Okay, we appreciate you being here, Mr. Wood.
Thank you, Mr. Chairman.
Okay, anyone else here to testify for, against, or on House Bill 305, the committee substitute? There being no one else, Mr. Hayes, would you like to close?
Thank you, Mr. Chairman, members of the committee. As a young lawyer, I worked in the Berry County DA's office and committed over 600 people to the state hospitals of the state of Texas, and had quite an experience with this very challenge. And it is one of the most challenging. And this bill is one piece of the puzzle. And I believe there's another bill out there that will get them there sooner. This is dealing with them when they get back. And would appreciate your consideration. And I will get with the Representatives Wu, Little, Money, and Jones and see if there's any other words. As I've thought about the jurisdiction question, Representative Little, I think we could probably interchange that with court. You know, D1 uses the word court, but I can also see why Ledge Council used the word jurisdiction, but I'm very flexible on that.
Any questions? Mr. Louderbacker? I'm sorry.
Representative Hayes, good bill, very much needed especially in the county jail world. The expense and cost is phenomenal, and the strain on county resources are very real. So appreciate the bill.
Yes. Mr. Money?
I'm looking at D1 and D-1 read together, which I should have done before you started testifying. And it looks to me like D-1, your committee substitute bill here, applies to cases, only the cases in which D1 applies, correct? This article does not require a criminal case to be finally resolved within any specific period, except that in a case to which subsection D1 applies, which
Correct.
means only in the cases where the court on its own motion has determined that that the trial is going to occur within 14 days.
Yes.
Okay. Then we have to have an evidentiary or procedural hearing within 14 days. So how do you still have a trial within 14 days if you have the hearing also within 14 days.
Well, you would do what? It says no later than 14 days, so you might have your competency, or you might have your initial pretrial conference immediately, day
Okay.
2, day 3,
so this
and then
isn't-
you would have your trial.
I'm sorry for interrupting. So this is not going to require courts to take up the matter within 14 days. It's only going to say that when the court has already determined that they're going to take it up within 14 days, this is when they have to do the pretrial hearings.
Correct, and yes.
Okay. Thank you.
Any other questions? We appreciate it, you're bringing the bill, and if there's nothing else, then the chair will withdraw the substitute and leave House Bill 305 pending. Thanks, Mr.
Thank
Hayes. Okay, Mr. Basut, you want to come up? I think you've got,
Thank you.
or Mr. You've got no witnesses, I think. I'm sorry. The chair lays out.
I defer to my seniors.
Okay. The chair lays out House Bill 307 and recognizes Representative Basut.
Thank you, Mr. Chairman, members of the committee, for the opportunity to lay out House Bill 307 for you today. This really is a simple cleanup bill, like legit, and we've passed it unanimously before out of the House last session. In 2021, the legislature passed HB 569, which, among other things, increased the credit a defendant receives towards fines from $100 to $150 for each day the defendant remains in jail. An unintended consequence of that bill, though, was as it was worded, we increased the credit for jail time, but we did not increase the credit for community service time, so we incentivized people to stay in jail as opposed to doing community service. All this bill does is increase the credit for community service and ensure that the jail time credit applies for time awaiting trial. That's it. Happy to answer any questions.
Any questions for Mr. Basut?
Just a quick question.
Ms. Jones?
What was the unintended consequence?
We incentivize people to remain in jail as opposed to getting out of jail and serving their community with community service, because you got more credit for time served in jail as opposed to credit for community service.
Okay.
Whoops.
I just was trying to visualize it.
Yeah, no worries.
And so we have no witnesses signed up for or against, and so you can go ahead and close if you want to.
I close.
And you finally did bring a simple little bill. That's
Just a simple
incredible.
little bill, Mr. Chairman.
Okay. So,
thank you guys very much.
if there's nothing else, then the chair will leave House Bill 307 pending for now. Thank you. Okay, the chair would recognize, would lay out House Bill 268 and recognize Representative Landgraf, or Chair Landgraf. We appreciate you waiting and being here.
Yes, sir, Mr. Chairman. I appreciate the opportunity to lay out House Bill 268, which seeks to reduce fake threats or hoax calls against a school. To that end, the bill proposes to elevate this crime from a state jail felony to a third-degree felony. And I filed this bill after a rash of hoax calls were made to schools in my district last year, threatening acts of mass violence. Now, thankfully, the threats did not materialize, but they were damaging in and of themselves. They resulted in entirely disruptive days at school, increasing absenteeism among the students, squandering law enforcement resources, and building a boy who cried wolf situation that could cost lives in the event of actual acts of mass violence. Now, constituents asked me to file this bill so that the law could serve as a stronger deterrent, thereby reducing chaos in our schools. And in preparing for this, I found that this is indeed a statewide problem. In 2024 alone, 799 arrests were made under this statute, meaning that these scenarios have unfolded approximately 1,000 times across Texas just last year. So by enhancing the penalty under this bill, I believe that we can bring that number down. Mr. Chairman, happy to answer any questions that you or the committee members may have.
Any questions, members? Okay, Ms. Rodriguez-Ramos.
Thank you. Thank you, Representative Landgraf. Your bill, does it, a lot of these kids probably do this without knowing anything about penalties or what have you. So where do you see in terms of the education, or what part of educating the students in their regular school day about these increased penalties to actually serve as a deterrent? What what do you see that part where the kids are actually being informed about these increased penalties
So,
without having been charged first?
Sure, no, it's a great question. I have considered that. I do think that there is a multiplier effect with statutory changes like this. So in other words, as we all know, there are copycat crimes, especially when it comes to this, especially if, now I want to be clear, in not every case this is a student calling in. It can be others who are just sowing seeds of chaos. But since you asked about the student example, you're right, they're not necessarily up to speed on the penal code and the potential range of punishments that could be or that could apply. But in reducing certain numbers, there is a multiplier effect that would prevent the instances of copycat activity. But then also, if there is a sentence that's carried out following a conviction, as we all know, that kind of word spreads quickly, especially among younger criminal defendants. Hopefully, it never gets to that pitch. But if so, I do think that this information does have a way of spreading and having that deterrent effect.
Okay, thank you.
Ms. Jones?
Do you have any statistics on who does the prank calling?
I don't have statistics. I do have some anecdotal evidence just from the rash of these that we saw in my district alone. I'm sure it could be fairly accurately extrapolated across the state, but in some cases they are students kind of playing pranks. In other cases, we have seen what I would consider to be terroristic threats by non-students who are calling into some of these schools. But there's not one particular profile that would apply across the board in my observation.
So here's my concern.
Mm-hmm.
Kids do bonehead stuff when they're kids.
Sure.
That's why they're kids.
Right.
And I would hate to criminalize a kid for doing kid stuff
Mm-hmm.
because when they're 21, when they're 25, they probably wouldn't do it again.
Mm-hmm.
And felonies follow you. And you think when you do stuff as a juvenile, it's going to stay you being a juvenile, but trust me, they come back and they use it. And sometimes they use it to enhance you, right? So being enhanced with a third-degree felony, I mean, then you've got, if you end up getting to a true habitual, right, where you have 2 prior third-degree felonies or higher, on your third one, then you're facing 25 to life. I'm really struggling with I'm really struggling with the over penalizing kids for dumb stuff. I think certainly if you're older, you probably should know better. But I'm struggling with kids.
Sure.
And then next thing you know, they can't get a scholarship or they can't go to college. I mean, and then the next question I was asked, if you got this, is it expungible, right? Because if it's not expungible, then they can pull it up and you've got a bonehead decision made, especially if it's a boy. You know what, I'm gonna take that back. But, guys tend to be more brazen when they're doing stuff. And because I noticed in your language, it takes the part out that said it was a state jail felony, which is already a felony.
Right.
And it takes it out of the state jail category and moves it to a third degree. And for people who don't know, you probably know, but this is for purposes of people that are listening. To state jail felony is range of punishment between 180 days and 2 years in state jail, day for day up to a $10,000 fine, where the facilities are more humane, quite frankly. To a third degree felony, which you're going to be in TDCJ, the range of punishment is up to between 2 to 10 years. Most times probation is an option, but a conviction for a third degree felony, those are considered major felonies. And you go to TDC, you ain't got no air, you ain't got no heat. It's horrible. Flies everywhere, people funky, because if you ain't got no commissary, you ain't got no deodorant, no soap, it's just awful. I don't even like to visit the jail to visit clients. And then you're gonna be sending kids who do minor stuff to an adult facility where they get to learn to be better criminals, maybe. So I'm just struggling with that
Well,
portion. I'm just,
Well, and if I may respond, Representative, so to your point, and just to provide some clarity for the benefit of the other committee members, yes, this crime is already classified as a state jail felony, which does obviously carry with it some serious consequences, some serious consideration. Certainly not to the same extent that a third-degree felony would. But we also, as I mentioned in the layout, are seeing instances in quadruple digits across the state of this happening, meaning that, and look, I get it, we don't want anybody to go to jail. That's part of the purpose of this, is to serve as a stronger deterrent. And this is, I think we can all agree, a very easily avoidable crime to commit. It does take an affirmative act by the criminal defendant to do this. It does require at least a certain degree of pre-planning. And so there is a way to prevent. We want to prevent this. We don't want anybody to serve any time for this, but that's because we don't want these criminal acts to be committed in the first place, because they do have wide-ranging and very serious implications for students as this relates to school and for the community at large.
I don't disagree that it takes affirmative act to commit any crime, right? Whether they're misdemeanors or whether they're felonies. You can't use a state jail felony to enhance to be a true habitual. So that's like a super meaningful distinction. I'm just really struggling with. And a lot of times the kids will be like on a dare. There's peer pressure. They hadn't thought all that stuff through. Not that I'm saying that we expect kids to do that, but I think a third-degree felony or TDC felonies need to be more than a prank call, even if they're at a school. That's just my opinion, but reasonable minds can.
Well, and under the current statutory definition, again, so the only change that this is making is the classification or reclassification proposed from a state jail felony to a third-degree felony. Which that's serious. What I'm saying is that there are still other elements that have to be met in order for a conviction to take place under the current statute. So it's more, I guess I'm pushing back when you're saying it's more than just a prank phone call, because it is more than that under the current statute.
Yeah, I wasn't a part of passing the original state jail.
I wasn't
one,
either.
Right,
I'm just reading it as it is. Right.
But I think TDCJ should be reserved for like really bad people who hurt people, not a prank call. And so anyway, but that's fine. We can stop this. I understand what you're trying to do. I just think it's too severe. But thank
you.
Any other Mr. Little?
Representative Landgraf, thank you. I have to say that I share Representative Jones' concerns about the penalty range, because I'm imagining that generally the people who are going to be subject to committing this offense are between the ages of 14 and 22 years old generally. I mean, is that your experience?
In some cases, but there have been other, I guess one of the most severe instances that occurred in my district last year at Permian High School in Odessa, the act was committed by somebody, I believe, who was in his early 30s. So not a student, not anybody affiliated with the school. And that was a more sophisticated incident of this where, it was very disruptive. So certainly there are cases where students are involved with this, but in, I think, some of the more extreme examples that I've observed, it was not just a student making a prank call.
And Representative Landgraf, I think I would, to somewhat dovetail with what Representative Jones is saying and what you're saying, I think I'd be inclined to increase a penalty range for someone who was not a student. If we got a 30-year-old man or woman calling into a college or a high school with a terroristic threat that causes them to roll EMS and SWAT, that seems to make sense. I have to express the same reservations Representative Jones has about a student. Also, something that didn't come up in your testimony but is apparent to me from the bill is you're including this within the cost-shifting mechanism of 42061, right? And so I'm imagining, absurd as this example may be, a 21-year-old girl trying to get out of a chemistry final and calling in a bomb scare, and then her parents get a $100,000 bill for rolling EMS and SWAT to the college or whatever. I mean, it is the intent of the bill to shift the cost of the emergency response to the offender, correct?
That's correct.
Okay. And do you have a sense, because I don't know, I'm asking you out of my own ignorance, do you have a sense of the cost of the emergency response that people would be required to pay?
So I have discussed with first responders in the aftermath of some of these instances, at least in my district, where, before a determination was conclusively made that it was just a threat and not an actual act of violence, that, in a community like the sizes of the ones that I serve, which are admittedly smaller than the ones that both of you represent, it really tied up all of the law enforcement resources for local law enforcement for basically an entire day, and that has a pretty significant impact on the ability to have a law enforcement presence just for normal daily operations.
Sure, it's got a price tag. I'm just curious
Yeah.
what that is, if any of these bills have ever been sent, like, here you go, pay it. And I don't know the answer to that.
So unfortunately, I don't have a hard and fast number either.
Okay.
Ms. Jones, or Mr. Money? Oh, I'm sorry, Mr. Louderback. Hard to keep everybody straight. Mr. Louderback.
Thank you, Chairman. Representative Landgraf, let me give a different perspective for the benefit of the committee and also to support what you're trying to do here. The cost to a, say, 5,000 community, 3A, 4A type school, 2A, 1A, 2A, which our state is comprised a lot of. When these things take place and it unfolds, we're looking at a myriad of problems that are pretty profound. Not only the risk to law enforcement arriving, to public safety, the fire departments, the different teams that are critical teams that are assembled at this point in time and are racing to this scene. But we also have now what we're dealing with in the lost education hours. The day is done. Educational-wise, the day is finished. From many superintendents, from arriving at these scenes, the parental issues, this ripples through a community like nobody's business. It is affecting everything to do, from social media to everything is exacerbated to a point where we're struggling with resource-wise, and you're very true that the resources are, other cities are coming because we don't know whether or not we have an active shooter. So you have a lot of different things meshing together in the public safety world in response to these threats. And so all these threats are taken seriously. All of them have a cost. To roll out in a town of 5,000 to 6,000 people, simply to roll out EMS, you're talking about $20,000. So just real dollars. So it's expensive, and it affects the community. It affects the ability for them to send their kids to school the next day. So it's a truancy issue. I'd like some figures on what you're seeing, if you had any data on truancy after this, and where you just had on absenteeism, where it goes up. I know in my district where it goes up. So these are things that we all have to try and blend in on the seriousness of the offense of what they're really doing. I got it, they're kids, and I got that they may not fully understand, but it's got consequences, and we've got to have consequences in place to stop it.
Yes, sir, I do appreciate that. And I think that does drive to the problem that we're trying to solve here. And I did speak with school district officials in the aftermath, and there were, I don't have the exact rates, but there were increases in both truancy and absenteeism after these events. And also, it's something that our community is very sensitive to, being the fact that 5.5 years ago, or within a 5-year period, our community was the location for a mass shooting on August 31st, 2019, that certainly heightens the sensitivities and awareness to these types of threats. And so it is something that we take very seriously. But also to that point, it is important to note that if we just continue to accept this, it does desensitize our communities to those threats, which makes it more difficult to respond to them when they actually do materialize. And I think that is an important aspect to all of this.
Agreed.
Any other comment, Ms. Jones?
So if the point of this is to pass off the costs, there are ways that the current bill does that. First of all, in a state jail felony, you can be fined up to $10,000. It is not, well, it is normal in cases where there is restitution to pay, that you require restitution if you get probation. So you can, for example, get state jail probation, and you got to pay back $20,000 or $30,000 before you come off of probation. So there are ways to pass off the cost to the perpetrator with the current law that does not put kids with grown folks over a prank. So if there were no ability to require restitution, but trust me, there are people that are placed on probation and they're not taking the pay it back part seriously, and they're due to come off probation, and they show up with their little lawyers and they're like, it's gonna end, and then the judge like, oh no, I'm extending you because you gonna pay this money. So there are ways to deal with it that don't treat petulant children who are probably not going to be the same 5 or 10 years from now. And we're also talking about bankrupting parents. And I mean, kids just do kid stuff. And to put them in TDCJ, and there's ways to get the money back, if that's the point.
That's not the exclusive point, but I think that it does help drive the point home that there are real and significant costs to the community, to the taxpayers that are associated with the response that these types of hoaxes and threats necessarily require, and who should bear the burden of that more than the responsible party.
I don't disagree with you, but as I said before, restitution places it squarely on the shoulders of the responsible party, well, probably and their parents.
Right. Well, I do appreciate the point that you and Representative Little made, and I'm happy to work with you on revising some language that would have two different classifications. One for somebody who's not associated with the school who makes one of these threats. I do see a distinction between that and a student who's just, using your words, doing kid things. I do think that, and in the observations that I've made, there are kind of a bifurcated class of these type of perpetrators.
And I also don't think you take, like my grandmother used to say to me, sweetheart, you're not the best thing you ever did, nor are you the worst thing you ever did.
Sure.
And I don't think we should pass a law that criminalizes everybody for the worst case scenario.
Fair.
Okay. Anything else? Mr. Money?
Yes, thank you, Representative Landgraf. Two instances came to mind as I read through your bill. One was when I was in college, every semester some moron would pull the fire alarm and evacuate the dorm in the middle of the night while we're trying to study for finals, and then the fire department has to come and clear the building, make sure there actually is no fire. It's a huge, even in that instance where there was no crime alleged, it wasn't a bomb threat, something else like that, it still is extremely disruptive to the sheriff's point, I'm sorry, the representative's point, sheriff representative.
It's a more sheriff's a more honorable title in my opinion, right?
So I thought of that, and there were a lot of nights standing out there in the cold that I wish I could have thrown someone in jail for doing this, and I take note here that according to the current law, that is still a state jail felony because it was at a higher institution of higher education. So it's already a state jail felony. I also thought of the congressman that didn't want to vote on the spending bill, and Congressman Bowman pulled the fire alarm and evacuated the Capitol, or whatever happened there. And I believe he was charged with a misdemeanor offense. I don't know what DC is doing, and I'm not saying we need to do it the same way they do it, but those two come to mind. And so I'm sympathetic to needing to do something to stop these kinds of things, but I also look, the very next section in the code is 42.0601, which is a false report to induce an emergency response. And this was just passed in 21, it looks like. But it creates a felony in the third degree if the false report was of a criminal offense to which a law enforcement agency or other emergency responder responded, and a person suffered serious bodily injury or death as a direct result of the lawful conduct arising out of that response. And so when I look at that section saying, if you call in, let's say you call in a bomb threat and someone injures themselves leaving, or you call in and you SWAT someone's house and they get shot, that is a third degree felony. It seems like not an equivalent punishment to say it's the same thing to pull that fire alarm at the school. And so while I want people to stop doing this because it's extremely disruptive, it creates fear and chaos and all those kinds of things. I think that that the current statute already creates a state jail felony in that sense, and that there is a heightened punishment for a false report that induces an emergency response where someone is injured or something like that in the very next statute. So
are you suggesting, Representative Money, that what we have proposed here in this bill would be more appropriate under 420601, or just that are you just drawing a distinction between the severity of what's contemplated in that section versus what we're talking about?
It's probably more that, like,
Okay.
The kid that pulls the fire alarm and it evacuates the school is already committing a state jail felony. I think to go to a third degree felony, like 42.0601, where someone is injured, and there's a criminal offense report, I think that it is appropriately a higher criminal offense.
Mr. Pradell?
Thank you, Chairman. Representative Landgraf, I can appreciate what you're trying to do here. I think we have to have accountability for people doing things like this. My biggest concern is maybe not so much with your bill, but just that, to me, a felony is supposed to be reserved for very heinous crimes. And I feel like we have pushed the term felony out there to pretty much, we hand them out like candy now to people. And so that's just my biggest concern is I want to make sure people who are, shouldn't be their whole life labeled with that term felony while maybe they didn't commit a heinous crime, even though they did commit a bad crime. So appreciate you being here. Thanks.
Okay, any other questions for the author? If not, Mr. Landgraf, we've got one witness who has signed up, so I'll go ahead and call the witness and to give you the right to close.
Thank you, Mr. Chairman.
And so the chair would call Mandy Zapata back up. And once again, Ms. Zapata, if you'll state your name and who you're representing and your position on the bill.
Hi, my name is Mandy Zapata, and I'm with the Texas Civil Rights Project, and I'm representing that and myself, and I am in opposition of the bill. Ms. Jones, you actually took most, if not all, of my talking points, so I don't have that much more to add. I do just want to bring to y'all's attention that the state of the juvenile justice system is already exposing kids to abuse and violating constitutional amendments. And so I think that we do need to be really mindful when it comes to choosing a consequence for youth. I feel like the way that you are talking about it, it has to be a criminalized consequence instead of just a learning consequence and education. A lot of kids that are going to school technically don't even know the law as it is written, so you're holding them accountable and having expectations for them that they don't even know that is acquired of them. And so I think this could be a learning moment for everyone in this room as far as if we want to have expectations for the youth, then maybe we need to let them know what the law is and what's expected of them. And I know right now they're not teaching that in the schools. Of course, we do want to avoid false threats, but respectively, we also want to avoid creating more and more felony convictions just for the need to make an example for it not to happen again. Thank you.
Any questions for Ms. Zapata? Okay. We appreciate you being here today. And is there anyone else here who wishes to testify for, against, or on House Bill 268? If there's no one else, then Mr. Landgraf, if you want to close.
Thank you, Mr. Chairman. I close unless there are any questions.
No, I don't think so. Any questions? I think we've covered everything. We appreciate you, Lena, and so if there's no objection, the chair will leave House Bill 268 pending.
Thank you, Brooks.
Mr. Tepper, let me get Mr. Guillen on. He's chairing a committee that's going. Mr. Guillen, are you ready? Sure. At this time, the chair would lay out House Bill 380 and recognize Chairman Guillen. Is there a substitute? No substitute on this bill, right?
Thank you, Mr. Chairman. Members, House Bill 380 ensures that individuals convicted of an improper relationship between an educator and a student, as well as those convicted of child grooming, are required to register as sex offenders. This closes gaps in current law and strengthens protections for Texas students. Under existing statute, offenses like sexual assault and indecency with a child require sex offender registration, but improper relationships between educators and students and child grooming do not. The bill corrects that inconsistency and ensures accountability. Educators hold positions of trust and authority, and when that trust is violated, it can have lifelong consequences for students. Additionally, child grooming is a serious offense that often leads to more severe abuse. This bill ensures that offenders in both cases cannot evade appropriate monitoring. We are working on a committee substitute that includes an important update, removing the statute of limitations for the offense of an improper relationship between an educator and a student, but we don't have that in front of you, and I just mention it just so that we can have a later conversation about it. Members, this bill strengthens protections for Texas children, holds offenders accountable, and reinforces our commitment to public safety. Last session, this bill passed unanimously through this committee and through the House and got caught up in the Senate. I can help answer any questions if y'all have any.
Any questions for Mr. Guillen?
Go on.
Mr. Little?
Very fine bill, Representative Guillen. Fully in support of it. I hope that you will not substitute in the limitations modification that may make it more difficult to pass. This should already be the law, and with any luck, it will be. One of the ongoing concerns that I have is the ability of prosecutors to plead cases down from this allegation so that they're never required to register and there's never any accountability at the educator level. But I want to commend your effort here and thank you very much for your presentation.
Thank you. Ms. Bowers, did you have? Okay. Anyone else? If. Sure. Louder back.
Thank you, Chairman, again. Nice bill.
Appreciate it. Thank you.
You got off easy. If that's all, we'll go ahead and call the witnesses. We have several witnesses in favor of the bill. First of all, the chair would call up Madeline Green.
Good afternoon, y'all. My name is Madeline Green, and I'm the legal researcher for the Texas Catholic Conference of Bishops, testifying in support of House Bill 380. The Catholic Church takes seriously our role in protecting children and putting an end to the evils of child abuse of any kind. That is why we take preventative and proactive measures to stop crimes against children before they happen. Our Safe Environment programs include regular background checks and educational programs to train clergy, staff, youth, and volunteers on how to recognize, report, and prevent predatory behavior towards minors. more than 2.6 million adults undergo background checks and safe environment training in the Catholic Church in the United States annually. But if even one child is harmed, one is too many. It is the responsibility of our government and the duty of our legislators to encourage proactive measures to stop predators and to provide equal opportunity for all organizations, public and private, with the ability to do the same. We all want to hire and retain employees and volunteers who have the best interests of children as their highest priority. The Texas Catholic Conference of Bishops supports House Bill 380 because it strengthens child safety measures by enhancing the sex offender registry with relevant data. House Bill 380 would include educators adjudicated or convicted of having an improper relationship with a student to the sex offender registry. Thus, we support this bill because it provides organizations serving vulnerable populations with a more robust sex offender registry so they can make safe and smart hiring decisions. Thank you.
Okay. Any questions for Ms. Green? Okay. Thank you for being here. We have John Wilkerson with the Texas Municipal Police Association.
Mr. Chairman, John Wilkerson had to leave. I am Brian Flatt, and I did register with TMPA.
Okay, then we'll call you. Thank you.
Thank you. So I am Brian Flatt with TMPA. Mr. Chair, thank you, and members of the committee. We're here today to wholeheartedly support Representative Guillen's bill to protect the children and hold violators accountable in the great state of Texas. That's the shortest thing that you're going to hear today.
Well, that was very short and succinct. Any questions? Thank you for being here and expressing that position.
Thank you.
We next have Brianna Waldock, and if I mispronounce anyone's name, I apologize. I'm reading off a very small screen here, so.
Hello, Chairman Smithy and members of the committee. My name is Brianna Waldock, and I'm here testifying for HB 380. I work for Tex Protects, and we're a nonprofit that advocates for strengthening families and preventing child abuse in general. But today I want to talk about child sexual abuse. I want to thank Representative Guillen for focusing on this issue. Tex Protects has been focused on ways to keep kids safe and specifically focusing on preventing child sexual abuse. Schools should be a place where kids feel safe and they should go there to learn and grow. But unfortunately, there are some other things happening in schools, and for some reason in school settings, we don't call behaviors what they are. We have normalized and watered down these inappropriate behaviors by accepting and using terminology such as an inappropriate relationship, rather than what is really going on, which is an adult abusing a child. We view this bill as necessary protection of children. I'm not personally a mother, but I can imagine that if my child came home from school or was groomed by an adult or had a teacher making sexual advances at them, I would want to do whatever I could to ensure future safety and navigate that situation with my child. I imagine that this bill brings peace of mind to any parent who's unfortunately having to navigate this situation with their own child. To conclude, this bill would help ensure that individuals who have engaged in this behavior will no longer have access to work in a place with children. We support this bill and appreciate all of you in the Texas legislature for y'all's commitment to protect children and keep schools safe. So thank you for your time. Thank you for all the work you've done, and I'm happy to answer any questions.
Thanks for what you do. Any questions for Ms. Waldock? Okay, thank you very much. Members, we have Faith Colson here.
Thank you, Chair Smithy and members of the committee. My name is Faith Coulson, and I'm representing myself as I testify in support of this bill. I was a victim of this crime, although it was in another state, so it was called something different in Illinois where it happened to me. When I was a junior in high school, my AP physics teacher asked me to stay after school to discuss college and careers. He then invited me to church, and over the course of a few months, he became a trusted mentor and a shoulder to cry on. He was a safe adult in addition to my 2 parents at home, or so I thought. In May of that school year, he kissed me, and within weeks, he sexually assaulted me inside the school building. He told me that day he was afraid of going to jail, and I felt the burden to protect him. The next day, I went to school, including to his class. This sexual contact went on for the remainder of that year, through the summer, across my entire senior year, and for almost 3 years after high school graduation. No one ever stopped him, and I finally got away at age 21, eventually changing my phone number and email to cut off all contact. It took me another 13 years to understand that I had been sexually abused. In fact, it took becoming a mother and seeing how vulnerable my own children were for me to realize that this was not my fault. We were never equal. He abused his power, and I'm still unraveling the many ways that his actions have impacted my life. Cheryl Shakeshaft, the nation's foremost expert on educator sexual misconduct, describes these abusers as killers of souls. Most teachers would never harm a student in this way, but those who do take our innocence and permanently divide our lives into before and after. We often suffer the additional harm of institutional betrayal when we find out that people at our school knew and chose to do nothing. And for those reasons, I appreciate the testimony already shared about schools wanting to keep kids safe. This pain of institutional betrayal can also lead to PTSD, depression, anxiety, health problems, self-harm, and drug use. Texas Penal Code defines this harmful sexual contact as a felony, but other sex crimes against kids have stronger protections. HB 380 would help address these disparities by making the crime subject to sex offender registry, and in the committee sub, extending the criminal statute of limitations. Other sex crimes against kids already have an unlimited statute of limitations, but currently this crime is limited to 3 years. Put simply, that is not long enough for victims to come forward. I was still in the abusive situation 3 years after it started, which is not abnormal for this crime. Even if the sexual contact had ceased, there are many hurdles that victims face in disclosing what happened, which is why it's normal for it to take decades for victims to come forward. Giving victims more time to come forward is necessary to make this law work as intended. Limiting us to 3 years means we have to forever live in agony that the person who abused us is out there, and we can't do anything to warn the public because it took us too long to leave, since no one saved us, or because it took us too long to recover from a harm that was inflicted on us. People who do this don't just stop. They only stop when someone stops them. The criminal statute of limitations extension would place the accountability on the perpetrator and not on the institution, since it's criminal and not civil SOL. Schools stand in loco parentis to students, which is why victims of abuse in schools need the same protections as their the same protections and their perpetrators the same accountability as in other sex crimes. We need justice and time to come forward, and you can help those already scarred and prevent more harm to other children. Please vote yes and protect your children and mine and everyone's grandchildren from this crime. Thank you.
Thank you, Ms. Colson. Any questions for Ms. Colson? And, you know, I guess we'll never know how common your story is because a lot of these go unreported.
They do, but the most current statistics, there's a book called Organizational Betrayal that just came out on this topic, and for when we include non-contact behaviors, the most recent statistics is actually 10 to 17% of students experience sexual misconduct by the time they graduate. So the number of people who experience what we would call sexual assault in other states and contact sexual abuse would be lower than that. But it's an epidemic that people don't realize. It far exceeds school shootings, and it's a safety matter that is very hard to talk about.
It's way too common, and
Yeah.
we need to, you know, if we can address it, we need to. I think we all agree on that. Any, Ms. Bowers?
Thank you, Chairman Smithy, and thank you, Ms. Colson, for I just wanted to say the courage to use your voice and to sound that alarm. And thank you even further for the statistics that you provided, because, you know, it is something that people keep silent about and just don't have the courage to stand up and speak out about. So thank you for sharing your testimony and for sharing your story.
Thank you.
I'm sorry, Ms. Jones?
Ms. Colson, I want to thank you for sharing your story. So I will share that I am a survivor of child sexual brutality, which I don't feel like going into details now, but I know that it started when I was 3, and I didn't outcry until I was 21. And I remember the difficulty, first of all, having the courage to speak, especially when it's somebody that people respected as it related to you. And how some people just don't believe that it happened and they think you're lying. And the years of counseling to try to get over it, but you never really do, because it affects you, affects your ability to build relationships with people, especially people who have a fiduciary duty over you. And so I know the committee sub is not here yet, but I'd be curious to know when it comes up, like, how long do you have? Because it's really traumatizing. And it's really interesting because sometimes you can think that you're over it, and on the outside you can appear really strong. And some stuff will just trigger you. It'll just trigger you and you'll just go back. And people are looking at you like, man, you so strong. I never thought that something like this would happen. And then when they threaten to kill you if you tell anybody, and they're way bigger than you and stronger than you. So I just want to thank my colleague for filing this bill, because it's a very difficult subject to talk about.
And I'm so sorry for what happened, and I appreciate all of the different the ways you're expressing the impact. And I think that's, I've heard it come up several times with the other bills, the concept of we need to make sure things are equitable and that there's parity and that the level of severity of the punishment meets the crime. And someone already brought up that we're not even calling this sexual abuse, we're calling it improper relationship, which is very sanitized. This is sexual abuse. This permanently harms people's lives. And the fact that it happens within an institution, and this is with no regard for blaming the institution, but just the fact that it happens in an institutional setting means that people take sides. And I'll share that 2 or 3 years ago, my son's former teacher was arrested, and my kids were thankfully not abused, but they were all very upset just because of the betrayal to them as members of the school community. And in that case, I was 17 when the abuse started. But in this case, this was a junior high kid, and she's still at that school district, even though the teacher's been arrested, and everyone blames her. And she's walking around being slut-shamed for something that a teacher did to her when she was in junior high, and that's what we face, whether we're facing it when we're still children or whether we're facing it as adults and people act like, why aren't you over this yet? We can't get out of our body, and so the trigger is always there. And there are things we can do to overcome it, and I would always encourage survivors, like, you can overcome and you can make good come from this, which is why I speak on this now, because I know that I couldn't get out. And whether it's the person is threatening you, or they're using love and affection and threatening to withhold that, or making it clear to you that you will ruin their life, which is how my abuser did it, I knew that his life was in my hands, and I knew if anyone knew, I would be called the slut. So it's not a simple thing to see, it's not a simple thing to report, and it's not a simple thing for someone to come forward because people take sides. So I appreciate the effort underway, and I know that Rep. Little, you brought up that extending statute of limitations can be a difficult thing, and I don't want to kill a bill by trying to extend it, but I did want to speak to it just because if you don't have time to come forward, it can make the bill very hard to ever have an effect, or the current law, which it's a great law. I'm glad as a mom in Texas that we categorically say teachers can't have sex with kids. Like, that's what it should be everywhere, and sadly it's not. And I'm still fighting for that in Illinois. I argued 4 years ago at a hearing, and they were like, but 18-year-olds can consent to their teachers. And so Texas has a good felony, but that limited SOL is going to really restrict victims. And the only reason I ever made a report, which I was able to do since I was abused in Illinois, I made a report because my mom told me 13 years after I got away from my abuser that he reached out to her on Facebook. And I was like, what? And I looked his Facebook up and had all these church quotes and Bible quotes, and I'm a Christian woman, but he used that to groom me, and it scared me he could do it in a church. The only reason I reported was because I didn't want him doing this in a church. There's no way for a victim to troll their abuser and make sure they're not hurting other kids. And the victim, that I know a lot of survivors now, and that's all we want. We don't want these people to abuse, and it racks your brain thinking, what if they're out there and they're hurting more kids and I can't do anything? So, again, it's a very hard thing to talk about, and my husband is now a teacher. He retired from law enforcement. He teaches criminal justice. My mom's a teacher. Most teachers are wonderful people. It's a very hard thing for schools to talk about because by talking about it, it implies something's wrong. But when a school is willing to talk about it and expose it, just like the person who already spoke from the Catholic, representing Catholic schools, when you're talking about it, that means you're trying to protect kids. But it is a hard thing, and it's not talked about enough to fix this. So I thank you for bearing with me. I appreciate the willingness to hear it out.
But I was also going to say that with institutions, they tend to protect themselves, right? So then they start making excuses, and then they start talking to lawyers. Mind you, that's funny since I'm a lawyer, but they start talking to lawyers, and they make decisions based on minimizing liability and not necessarily always doing what's right. And I'll also say that, and I've seen it, I mean, I was a high school athlete, and we knew the coaches that were doing stuff, or we suspected they were doing stuff, and of course, a lot of times the kids, and this wasn't my case, but a lot of times the kids like literally think they're in love, right? They really aren't able to give consent, even though some people think it's like blaming the victim.
Yeah.
You do all these things some young kid never knew could be done. You know all the young kids' insecurities. You become that Prince Charming or Princess Charming, and that kid thinks that they love you, and years later, you realize they were abused. And so, again, which is why I want to know what the statute of limitations is, because there are a lot of other factors that impact whether you have the support to move forward to complain, right? Because you may not even know it's abuse, right, until later when you have more lived experiences. So anyway, thank you for bringing the bill.
Okay. Anything else, members? Ms. Bowers?
Thank you, Mr. Chairman. And so, Ms. Colson, you said you were abused in Illinois. Did it become law in Illinois, or was, and this may be a question for my colleague, Representative Gann, but do you know if the law was enacted there in Illinois based on this same kind of instance?
So I actually had worked, when I first came forward, and I actually was able to press charges in Illinois, and afterward I wrote my local lawmaker. I was living here in Texas. I've been here for 12 or 13 years, but since it happened there, I was like, I'll do my civic duty and email my lawmaker where my parents live. And she responded, and they actually passed a law, and they named it after me. Now, that's how I found out. Someone reached out, someone is with me today that had reached out because they heard of that, and that's how I found out about some of the challenges in Texas. But to answer your question, in Illinois, if my teacher would have waited till my 18th birthday to touch me, there would not have been a crime, and there's still not a crime. I'm still fighting that to this day. There's been like 4 bills filed. But because I was 17, it's not called improper relationship with a student there. It falls under their sexual assault and sexual abuse laws. So they have a provision that the age of consent is extended a year if there's a position of trust. So that's where the charges came. So when I made a delayed outcry, they said, we don't just have to prove the sex, we have to prove the timeline. And in my case, they were able to corroborate that I was underage. But there is a criminal law already. The challenge there is if you're 18, it no longer applies. The challenge here is it applies to all ages, which is what it should be everywhere, but there's the shorter statute of limitations. So I also know a survivor from very similar story to mine in Illinois. She's only 4 years older than me, and the way that slowly the statute of limitations had been extended, she barely missed it because it had expired before it was extended, and it would take a constitutional amendment to retroactively apply that. So that's the other reason why, even though I'm not here to try to say we should retroactively apply a new statute of limitations, but we have to start moving that now so that the victims, as they come forward, have an opportunity to to make that outcry. Did that address your question?
Yes, thank you. And then some. But I also want to address I think something you talked about, it's saying improper relationship. So improper relationship sounds like the victim consented. So is that where you were going with that as well?
I care less about the title of the law than the impact of it. And so the meaning of the law is that if there's sexual contact, it's a felony, no matter the age of the student, which if I've now have supported advocates in multiple other states, and that's what I would say, like every state should not have an age cap. If a teacher's having sex with a student, the student cannot consent, like period. The term is a little bit problematic, but the term does not impact the application of it. So I'm not here trying to advocate for the changing of the name, but I know survivors who are like, why is it even called that? It's not a relationship, it's abuse. Right. And I agree with that logic, but I'm not here trying to say we also need to try to change the name. The bigger problem to me is, there's crimes that have a far smaller impact, that have statute of limitations that far exceed this. And as a survivor of this, it's basically like if I were 16 and abused by someone outside the school versus 17 and abused by someone inside the school, in a sense, you're treated almost like a second-class citizen. And to the point that was raised about institutions and kind of protecting themselves, I'm not saying most institutions do that. That does sometimes happen. But where the bigger problem is with a survivor coming forward is it's everyone draws lines. It's a beloved teacher versus a student, and who do you believe? And that's where maybe the student, prompted it, or maybe this, and that's why the law reads that it doesn't matter the age of the student. It's a felony. That the teacher has the responsibility to hold that boundary, but it does impact people's awareness of the situation. If they don't know that it's common, it's easy for them to blame the victim or to not believe that it even happened. Sure. So there's a lot of the law, besides the statute of limitations and the disparities we're talking about today, it's a good law. But then there's the cultural awareness piece where that's a whole nother matter, where we're really making sure schools know not to ignore those red flags. If there's a colleague and they're like, I don't want to believe this about my colleague, that's a really icky feeling I get to think that my colleague might be doing this. Well, you're still a mandated reporter and you need to report suspicion, but that's a whole nother matter.
Yeah, and I didn't mean to lead you down that path, but I do have a problem with improper relationship. And so hopefully we can talk about that and look at it. And thank you for your.
I'm happy to talk about it as much as I'm just saying I don't want to derail the progress that could be made just because of that. So.
Of course, and neither do I. And I, have great respect for Representative Guillen, and I do agree with the bill and legislation as it's been filed, but that whole piece seems to me lends itself to like it was a relationship, a consensual relationship. And when we get into victims and abusers, we need to not have that skewed at all. So.
Yeah, thank you. I appreciate it.
Thank you.
Just a little bit of speculation on that, but I think you may eliminate or tie the hands of a prosecutor if you try to tighten that up. Right now, it makes it where there's a lot more conduct that's going to be captured by improper relationship as opposed to just sexual contact. And so,
well, the actual penal code is.
I've seen it.
Oh, okay. Sorry, my understanding was that it does require contact.
Right.
Under the penal code. So.
I think I would be careful about changing the title.
Yeah, no, that's what I'm saying. I'm not out here to try to change the title, but I appreciate the understanding of the label not being helpful.
Thank you, Ms. Coles. Representative Rodriguez Ramos. Were you not finished? I apologize.
No, I was completely finished, but I was going to just say thank you. I think he was trying to explain that to me.
Yeah.
He was.
Yeah, I mean, that's just my 2 cents on it. So, I mean, and I'll be the first to acknowledge it's not my expertise either, but because I had this thing, I pulled it up for that reason, because when you said it, it kind of rang a bell for me as well. So I pulled it up, and the title does make it sound a little bit uneasy, but it also, when you think about it, and I know there's probably prosecutors in the room that could give opinions better than myself, but I think it probably captures more conduct.
Okay, thank you, and thank you again, Ms. Coles.
Thank you.
Representative Ramos.
Thank you, Mr. Chair. And I want to thank you for your testimony and for sharing with us something so intimate. And this law is great, and I think that we should, in this space, this is where, if we talk about elevating penalties, as you mentioned, and going back to what Rep. Bowers was talking about, the difference between, you mentioned somebody from the outside versus somebody in the inside, is that there is a space of trust, and that when you send your child to school, there is the power dynamic, but not only that, as parents and as a child, you drop your guard in many spaces because of the space of trust, and you're hoping that in this environment, you're there to learn and to grow, and an individual is not going to take advantage of that. And so I think it's wonderful that we do register these individuals as sex offenders so that they're not able to violate that space of trust. I mean, it's like being in a fight out in the street versus domestic abuse. Those are different spaces where the expectations are a lot higher when you have that relationship with someone. So thank you so much for coming and testifying, for changing the laws in Illinois and helping Texas be a better space for our victims and survivors. Thank you.
Any other questions, members? Okay, thank you for being here.
Thank
We
you.
appreciate you sharing your story. We have Kelly Niedert here.
Hello, my name's Kelly Neidert. Oh, sorry, did I cut you off?
No, not at all.
Oh, sorry.
No, that's perfect. I mispronounced your name, and I'm sorry.
Oh, yeah, it's all good. I'm used to it.
Well, I am too, so that's.
My name's Kelly Neidert, and I'm the Executive Director of Texas Coalition for Kids. Thank you for the opportunity to testify in support of House Bill 380, a critical measure to protect Texas students from predatory educators. Just last month, a teacher at Newman International Academy in Arlington was arrested for an improper relationship with a student. The school's police chief stated that after further investigation into this incident, it was discovered that this teacher had actually been involved in similar incidents at other schools in DFW, but he was allowed to quietly resign, and he was rehired at this school, so he avoided real consequences and he was able to offend again. HB 380 closes this dangerous loophole by requiring all teachers convicted of improper relationships with students to register as sex offenders, ensuring that their history follows them and they cannot simply move to another district unnoticed. Additionally, this bill includes child grooming as a reportable offense. By recognizing grooming as a crime that warrants sex offender registration, HB 380 strengthens protections for students before abuse occurs. This bill is a necessary step to increase transparency, deter predatory behavior, and prevent repeat offenses in our schools. No teacher who has engaged in sexual misconduct with a student should ever have the opportunity to re-enter the classroom. Please support HB 380 and put an end to this cycle of abuse. Thank you for your time.
Thank you, Ms. Niedert. Appreciate you being here. Any questions? Okay, thank you very much.
Thank you.
Mr. Wilkerson John Wilkerson I'd called him earlier. I assume he's not back. And so is there anyone else here to testify for, against, or on House Bill 380? Seeing no one, the chair would recognize Representative Guillen to close.
Thank you, Mr. Chairman. I'll work out final language with y'all and get something back to y'all as soon as possible. Appreciate the opportunity to lay it out and appreciate your consideration.
Thank you, Mr. Guillen. Any other comments or questions before he leaves? Okay, thank you. We'll let you get on with your work.
Thank you.
Mr. Tepper, if you're ready, the chair at this time would lay out House Bill number 548 and recognize Mr. Tepper. And before you open, let me just say, so members, we go into session at 2 o'clock, so it would be the intent of the chair to go to work to maybe 1:45 or 1:50, and then break to go to the floor. Is that okay with everyone? So this is the last one. So we have
Move it along, Mr. Tepper.
we have 5 witnesses. So if we want everybody to say what they have to say, but if they'll just talk fast, maybe we can get out of here by 1:50 or so. But go ahead, Mr. Tepper. And is there a substitute or not?
No, sir.
No. Okay.
Chairman Smithy and members of the Criminal Jurisprudence Committee, thank you for allowing me to lay out House Bill 548, a committee made up entirely of attorneys, so this should be fun. I didn't get the memo. Texas is facing a rising challenge in combating vehicle-related crimes. According to a National Insurance Crime Bureau study, Texas is the second highest rated state for car thefts, first in car burglaries. This represents a significant increase as Texas moved up 7 spots from its 2022 ranking. House Bill 545 seeks to reduce the occurrence of vehicle burglaries by increasing certain criminal penalties related to the offense. My bill makes the following changes. If a person commits car burglary and has not been previously convicted of the offense, the current penalty is a Class A misdemeanor. My bill increases this penalty to a state jail felony. If a person commits car burglary and has been previously convicted of the offense, the current penalty is a Class A misdemeanor with a minimum term of confinement of 6 months. My bill increases this penalty to a state jail felony with a minimum term of confinement of 1 year. If a person commits car burglary and has been previously convicted of the offense at least 2 times, or if the vehicle or part of the vehicle broken into or entered is a rail car, the current penalty is a state jail felony. My bill increases this penalty to a 3rd-degree felony. By increasing penalties for repeat offenders, the bill claims to deter individuals from repeatedly committing burglary of a vehicle, recognizing that habitual offenders often need stronger deterrents. I'm happy to answer any questions you may have.
Okay, any questions for Mr. Tepper? Mr. Little?
I have some questions. Representative Tepper, I'm struggling with an aspect of your bill, and the concern that I have is, as things sit today, if there's a burglary of a vehicle, it's a Class A misdemeanor, except it's stepped up if there are repeated offenses. That part remains the same for your bill, I believe, but the concern that I have is if somebody steals my briefcase with $1,500 cash in it, that is a Class A misdemeanor under theft. But when I went to law school here, had my car broken into, and somebody stole a Swiss Army watch that my mother gave me, it couldn't have been worth $200. And under the proposed bill, that's instantly a state jail felony. So one of the issues that I have is that it's disconsonant with other aspects of the penal code. So when there's a theft between $750 and $2,500, that's still a Class A misdemeanor. But if any type of burglary of a vehicle occurs, it immediately becomes a state jail felony. So I'll just pose that question to you. Have you considered that, and what do you think about it?
Yes, sir. We've considered it. I've noticed a trend here in some of the other bills laid out where I think first you need to realize that chances are this was a repeat offender already. Now, we caught them one time, but with the burglary rings that we've seen around Texas, chances are there's more than just one watch stolen, although that is the incident there. And I'm sure your legal background can argue that better than I could and go back to the one time they were caught and the watch. The other issue we're having is such an increased amount of this crime warrants an increased penalty. And if you're going to use comparisons, the catalytic converter theft has the same consequences as my bill would give you if it was indeed passed. So the catalytic converter isn't even inside the car, it's outside the car. So I'm really just bringing the car burglary up to the level of even a catalytic converter theft.
Okay, thank you.
Any other questions? Mr. Money?
Well, one thing I would say to that as well is there is something increasingly violative of breaking into a vehicle and stealing something as opposed to stealing something in plain sight. And I don't know. And so for us to recognize that in the law, if you go into a store and steal, $1,000 worth of stuff, that's a certain crime. Or if I swipe something when I'm at your house, but if I break into your car while I was sitting there, there's something. I think that I don't think it's as hold on.
Feels more like a personal violation.
It feels
perhaps.
more like a personal violation with that. I don't know where I am on this yet or not, but well, I'll just stop there.
Ms. Jones, did you have something?
I'll wait till the conclusion because I want to get through these witnesses so I can go eat.
Ms. Bowers?
Thank you, Chairman Smithy, and thank you, Representative Tepper. Can you explain the fiscal note and the impact, the negative impact that I see here?
We're looking at increased in jail time and the cost of that. Did I answer your question?
I believe so. But, you know, when we look at legislation, we always like to look at the fiscal note and to know what that impact is going to be. And it looks like it just shows that there will be a negative impact, correct? And that is, you're saying with increased jail time?
We're looking at, from my memory, and I'll have to look back at it, I thought we were looking at an increased fiscal note impact. Is it showing a negative there?
It says has introduced a negative impact of $4 million, above $4 million.
You know, I don't recollect.
Through the biennium ending August 31st of 2027.
Not advised. I don't remember why they came up with a negative impact on that. I thought it was a positive impact, but that might have changed.
Okay, and so I'm sure that you and I can discuss this further then, if you have no answers right now.
I'm not advised, Representative. I'll get back with you on that.
Okay, wonderful. Thank you, and thank you, Chairman Smithy.
All right. Any other questions? If not, we'll go ahead and call witnesses. Mr. Tepper. Okay, we have Jennifer Szymanski for the bill.
Thank you, Chairman Smithy and members of the committee. I'm Jennifer Szymanski. I'm the Deputy Executive Director of the Combined Law Enforcement Associations of Texas. We represent 28,000 law enforcement officers across the state. Today, here testifying in support of...
Oh, okay, I'm sorry. I didn't mean to interrupt you.
Well, that's okay. In support of House Bill 548. I took a lot of notes on that last bill, so I'm going to try to cipher through those quickly. I'm here to support the San Antonio Police Officers Association and their business community, as well as other large metropolitan areas experiencing alarming trends related to property crime, specifically burglary of a vehicle. Just 2 nights ago in the city of Austin, we believe we had an individual who interrupted a burglary of a vehicle and was murdered. It's still under investigation, but that was 2 nights ago here in Austin. The number of repeat offenders, violent offenders committing these offenses should send a message to the justice system that the penalty is not a sufficient deterrent. These trends do not account for unreported BOVs that are typically the result of law enforcement staffing issues and the sheer number of calls for service related to this offense. The safety and quality of life is negatively impacted by these types of property crimes, and it also strains the relationship between law enforcement and the communities they serve. When perpetrators are not punished for their crimes and are back out on the street to commit these crimes time and time again, public trust is lost. Our officers are the face of the justice system, and our officers, as well as the community, must feel as though these perpetrators are going to be held accountable for their actions. This enhancement is long overdue and would greatly enhance the system's ability to hold criminals accountable. And I think it keeps it simple. We do support the other bill that was discussed today. A couple of things I want to comment on that were said. MVPA, or the Motor Vehicle Prevention Authority, absolutely. Of course we need to fund that. We've always needed to fund that. That comment came from a group that ironically also wanted to defund the police. So we absolutely support funding MVPA fully. Also wanted to mention, it was just by Representative Little, I agree with Representative Money about the intrusion. I think the difference between these is the intrusion, the burglary of a vehicle and or theft of person, for example. That's an enhancement. Theft of person, when you take something off of someone as opposed to swiping something, I think that's different. Also, deadly force encounter. This is a burglary of a vehicle at nighttime is a justified deadly force encounter by a civilian in their home that might happen to encounter this. So again, penalty not really matching what these kids in some cases are out there committing BOVs in neighborhoods, and it's extremely dangerous. These, again, misdemeanors they're not being punished for. it just doesn't match. It's not a good deterrent, and it's extremely dangerous for these kids. It could be justifiable homicide if confronted.
All right. Any questions, members? Not. Thank you very much.
Thank you.
The chair calls Trish DeBerry.
Good afternoon. Pleasure to be here today. Chairman Smithy, members of the committee, move this closer. I'm Trish DeBerry, President and CEO of Centro San Antonio. So we are tasked with keeping downtown San Antonio not only clean, not only beautiful, but most importantly safe. Every day in San Antonio, a resident or a tourist becomes the victim of a car break-in, not only causing damage to the vehicle, but to their pocketbook and to Representative Money's comment, to their psyche, right? It is a personal violation.
Let me get you to stop and just your
Yes.
position on the bill.
I'm in support.
Okay, good.
Yeah, sorry about that. Citywide, there have been, between the months of December and January, more than 400 burglary of vehicles in San Antonio. In downtown alone, in that same time period, 60. In fact, during last Fiesta, which was a big deal for San Antonio, we had more than 30 cars that were broken into in a valet parking lot. So that dissuades people from coming into downtown and questioning, is it worth it to come into downtown? So I do believe that we have reached a crisis escalation of this issue, not only because of the rampant number of burglary vehicles that I just talked about, but because the offense puts the lives of our San Antonio police officers in jeopardy every day, because many times a car break-in leads to a shooting. Chairman Smithy, you alluded to that, but I've got another example. Just this past summer, a vehicle in the River Center Mall parking lot was being broken into when the owners of the vehicle came out of the mall. Both the perpetrator and the owners of the car had guns. Gunfire erupted, people were shot, and transports were made to hospitals. For this reason and many others, Centro San Antonio supports the upgrading of the offense associated with burglary of a vehicle to a felony offense. We believe it will serve as a strong deterrent to the crime because those thinking of committing the offense might think twice about it before it becomes a permanent part of their record and/or they may serve real jail time if arrested. Tourism is a major part of San Antonio's economic engine. We're preparing to host the Final Four, the men's NCAA Final Four, in 3 weeks, where we will welcome thousands of visitors to downtown San Antonio. No doubt March Madness will definitely be a reason to celebrate, but the madness associated with burglary of a vehicle that could affect one of these visitors is certainly no joke. We must have reform, we must have accountability, and most importantly, there must be repercussions for a crime that to date has had little to no consequence. Thank you.
Thank you, Mr. Berry. Any questions? Thank you very much for being here. We have Kathy Mitchell.
Thank you so much. I am here to speak in opposition. And I do want to pick up the thread, exactly the thread that I had not gotten a chance to discuss in our first round, is the issue of preventing.
And I need you to say where you are on the bill.
Oh, I oppose the bill.
And who you're representing.
Equity Action.
Okay, thank you.
So I just reviewed the fiscal note on this bill, and I note that 764 people were prosecuted for the Class A misdemeanor of burglary of a vehicle in Texas last year, according to LBB and its good fiscal note people. There were an estimated 200,000 burglary of a vehicle, according to the Motor Vehicle Crime Prevention Authority. The gap that we're falling into here is largely a gap of enforcement. It's not about the penalty, it's about the fact that 96 or more % of people who open a car door and rifle through your car are going to get away with it. If people don't believe they're going to be caught, they don't stop doing the thing and no increase in penalty is going to impact that moment where I look around and decide I'm going to pull a car door open because I don't think I'm going to get caught. Now, we've had this debate, I'm going to be like the grandma in the room now. I have been doing this for a very long time, for many different organizations over many years. And the Motor Vehicle Crime Prevention Authority was actually a solution-oriented step forward that we took because of exactly the problem of enforcement. These crimes are hard to investigate. Finding the people who are doing this many times requires a sometimes lengthy investigation where you tie together a lot of separate and disparate incidents, identify people, do more investigating, and really uncover what's going on. Now, this last week, headline news in Austin, there was a ring of burglary of a vehicle. Can I proceed? Because I think this is just a thing you might want to know. 12 people were arrested. I only know what everybody else does from the press coverage. But they announced that this had been a 9-month investigation. So these investigations are resource intensive. They require a lot of people and thinking and processing. And that is what we expect our police to be doing. So the issue isn't so much that they don't know how, it's that it's an allocation of resources. And generally, most people want to see police spending their resources on violent crime. So this is that tough call. How do we ensure that this is getting investigated, even though many of the perpetrators really are kind of the little guy? So again, I just would suggest that you get some testimony from the motor vehicle folks who are already in place to deal with this crime and not create a penalty increase that will disproportionately impact that first offender who's a pretty small fish because we already have felony offenses currently being charged for all of the kinds of crimes that you've heard about today. Thank you.
Okay, let me ask you one. Well,
Yeah.
First of all, I've got to clear this up. Your witness affirmation indicates that you're testifying on behalf of Equity Action and yourself. Is that correct?
Correct.
Okay. All right. Now, you mentioned that about 96% or so of these offenses are never don't result in a conviction. Do you have a breakdown, or do you know of a breakdown as to the ones that are not resulting in a conviction? How many of those are where they never identified the perpetrator, or how many where they identified the perpetrator, but the prosecutor made a decision not to prosecute?
So we don't have good data on arrests from all jurisdictions. There's a kind of a gap in the data. So we know from the motor vehicle people here, they estimate 200,000. In my jurisdiction locally, there are about 8,500 reports, incident reports related to burglary of a vehicle. A much smaller number have resulted in arrest. So that's the gap, and I can bring you that number, but I don't have it today. Okay. It's a big gap, like a small number of arrests relative to the 200,000 estimated incidents.
Any other questions, members? Mr. Cook?
Have you read this bill, or only the bill
Yes.
that we heard earlier?
No, I read both bills.
Okay, because this one deals with repeat offenders, and you said that this bill disproportionately impacts first-time offenders, so I just wanted to...
It's my understanding that a first offender under this bill would also get a state jail felony. If I'm wrong about that, then I apologize.
Except the offense is a state jail felony with a minimum confinement of 1 year if it is shown on the trial of the offense that the defendant has been previously convicted of an offense under this section.
Okay, well, I apologize for that error.
We don't need to apologize, just want to make sure that that was pointed out, that this is not a bill that disproportionately impacts first-time offenders, because it's going after people that have been previously convicted. And it's my understanding your organization also supports defunding police, and so your other argument is that you thought that it was just an allocation of resources. What's the problem?
I would just beg to defer that we support defunding the police. That is a meme that's out there.
So Equity Action has not previously taken that position?
No.
Okay, thank you.
Any other questions? Mr. Little?
Smithy. I actually read it the same way that you did, that this is going to be a state jail felony on a first-time offense. So as I'm reading the bill, 3004D is amended to read an offense under this section as a state jail felony, and it becomes duplicative, but it says except that, and you have subsection 1, the offense is a state jail felony with a minimum term of confinement of 1 year if it's shown on the trial that the defendant is previously convicted. So as I understood this, it is a state jail felony on a first offense, and if it is a repeat offense, then you've got a minimum 1 year under D1. So if I'm mistaken, please someone, right? Is that how you read it?
That's how I read it, but I don't have, unfortunately, I didn't bring the bill language, so I don't have it in front of me.
Okay.
Well,
I just wanted to clarify and make sure.
We may ask the author to clarify his intent.
I think Representative Tepper will clarify for us.
Okay. Thank you for being here. We appreciate it. We have Mandy Zapata. Ms. Zapata still?
Good afternoon. My name is Mandy Zapata, and I am with the Texas Civil Rights Project, and I'm representing myself as well. And I am in opposition of this bill. I will say that we can reference back to a little bit of the testimonies that happened with HB 727 as far as just over-criminalization of circumstances and different things that already have penalties within the penal system. I think that something that Ms. Kathy brought up was the gap when it came to, is it the idea of giving them a harsher punishment or actually just finding the people to hold them accountable? And the gap that I got from the Uniform Crime Report data, and it's from 2020 to 2024. In 2024, the clearance rate of them actually having a resolve was only 9.6%, and it hasn't been over 10% in the last 5 years. And what I'm most concerned about is the percentages of individuals that were kind of in the age range of this was from 10 to 24 was 25%. And I know that's only 25% to some people, but that's 25% of kids and young adults that I'm going to fight for and I'm going to recognize, because, again, the more that we just keep punishing and being punitive, the less results and actual investment we have in the community and society as we go forth. Thank you.
Yes, thank you for being here. Any other questions, members? Any questions? Okay, thank you very much. Our final witness, members, is Nicholas Haynes. So you have the distinction of being the final witness of the day.
And I am aware that y'all are ready to go to lunch. Good afternoon, committee members. I'm Nick Haynes, Regional Vice President for Block by Block, and I speak as an individual in favor of House Bill 548. And while I do not speak for my employer, my experience as a service provider for downtown clean and safe programs in San Antonio, Houston, Nashville, and Austin, Texas, amongst many other cities, gives me valuable insight into this issue. And while I don't want to see more people incarcerated, I believe that increased penalties would have a deterrence effect, making stricter penalties that discourage individuals due to fear of consequences. And also, as a proud second chance employer, my personal passion is empowering many of our ambassadors to reset their personal understanding of risk versus reward. My experience shows that the effort should be in encouraging individuals to reform, not minimizing criminal behavior or blaming the victim, but to stop their criminal progression. And finally, to reiterate, these negative impacts that we see include increased cost and lost revenue in our downtowns and public spaces, and this affects tourism, business patrons, and residents. The damaged reputation of those public spaces, including downtowns and parks. My background is in retail and sales, and it's much, much easier to lose a customer than to gain one. In a lot of these negative experiences, we lose customers. And then the other considerations, as these thefts increase, our safety patrols have increased, and our ambassadors are increasingly at risk dealing with issues that we're really not equipped to deal with. But due to the severity and the nature of it, we do what we can to deal with these issues. So with that, I am done. Any questions from you folks?
Okay, any questions, members? Well, I think that we're questioned out right now, so we appreciate your testimony, as everyone else today, and thank you for waiting as long as you had to wait to testify.
Thank you.
Thank you. Is there anyone else here to testify for, against, or on House Bill 548? If not, Mr. Tepper will recognize you to close, and you might, in your remarks, clarify a little bit of confusion about who this would apply to.
Yes, it applies to a first offense, and it ratchets up every offense thereafter by one penalty. Does that clarify it? Representative Little is correct. I think that the coddling of the youthful indiscretions, I think the public's had enough, and they are ready to protect their property throughout the state. So with that, I close.
Okay, any other questions? Ms. Jones?
I think reasonable minds can differ. And when I hear talking about downtown, and I used to be on city council in Houston, I find that in downtown areas, you'll have a lot of homeless population and you'll have a lot of mental illness downtown. You'll have a lot of poverty issues, and I'm certainly not saying that we should make excuses, but we're criminalizing poverty, and I do not believe the first time you commit a crime, it should be a felony, especially as it relates to property crimes. As a person who's had my car broken into, my house broken into, I ain't feel like it, telling you all the things that have been stolen. Well, while I'm venting, a $5,000 leather coat. I don't even want to know how much they gave it to the pawn shop for. I'm still having nightmares over that. From North Beach Leather that I bought in the Galleria in Houston. But when I'm in the courthouse and I'm dealing with these things, you can have all the laws on the books you want. If you don't have prosecutors to prosecute them and you don't have law enforcement to arrest them, it's not going to fix the problem. And most people that I represent, they literally don't think about the consequences. I mean, most crimes are crimes of necessity. So as a 30-year criminal defense lawyer, something like I would never do is leave stuff in my car. You'd be surprised at the number of people that'll walk by a car and be like, oh, do I see some stuff in that car? God is telling me I should break into it. They're like crimes of opportunity. They're not even starting out saying I'm going to do this, right? And so I don't know what the answer is, but I don't think criminalizing a first-time property crime offense is the answer. And I'll just tell you that. And I also don't think that it's minimizing what they do for what that's worth. But I'm happy to talk with you or whoever's working on it in your office, in my office, just about if there's a way to figure out how to, I guess, with specificity or with focus to try to help out on that issue.
Ms. Bowers?
Thank you, Mr. Chairman, and thank you, Mr. Tepper. I do want to clarify the fiscal note and the LBB The LBB's analysis does say that the bill would make no appropriation. However, it could lead to and could provide legal basis for the negative impact. So I'd love to talk to you about where that negative impact would come from, estimated over the 2-year period. So I just wanted to clarify that.
Anything else? Okay, Will, if there's nothing else from you, Mr. Tepper, the chair will leave House Bill 548 pending for now. Thank you. And we appreciate everyone being here. We had a number of people who signed up for and against bills, but who elected not to testify. I want to assure you, your position will be made known to the committee members as we deliberate these bills. And if there's no other business before the committee will stand adjourned.